Rise, jury, in your courtroom.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good morning. Welcome back. Happy Tuesday. We got you in the courtroom right about 10 minutes after I expected to start, so I don't know that it's necessary. I can save my spiel about taking full responsibility. We're pretty close to on time today. So first thing, as always, though, that I need to ask you is, was anybody, by show of hands, exposed to anything about this trial between the time you left the courthouse yesterday or the courtroom yesterday and the time that you returned into the courtroom today, by way of media, discussion, anything in any way, shape, or form about this trial outside of the courtroom, by show of hands? Let the record reflect there are no hands. Again, thank you all very much. We are going to pick up where we left off, and at this time I'm going to ask the state to please call their next witness.
The state calls Michelle Rogers.
Michelle Rogers. Okay, yeah, I'm going to do it when she comes in. Ladies and gentlemen, before this witness testifies, I have a brief instruction. I just didn't want to start reading it, and then she came in like this, so I'm going to wait till she comes down here, and before I swear her in, I'm going to read you a brief instruction. Ms. Rogers, good morning and welcome, ma'am. I'm going to swear you in just a moment, but I need to read an instruction to the jury first. The evidence that you are about to receive concerning other crimes, wrongs, or acts allegedly committed by the defendant will be considered by you for the limited purpose of proving intent, identity, or the absence of mistake or accident, and you shall consider it only as it relates to those issues. However, the defendant is not on trial for a crime, wrong, or act that is not included in the indictment. Ms. Rogers, if you'll raise your right hand, please. Thank you. Do you swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, I do.
Thank you, ma'am. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat. Make yourself comfortable. That microphone in front of you is on, and it is fully adjustable. You let me know when you're ready, and then I'll let the attorneys proceed.
I'm ready.
You may proceed, Mr. Diaz.
Thank you, ma'am. If you would, please introduce yourself to the jury.
I am Michelle Rogers.
And Ms. Rogers, I want to ask you, do you know someone by the name of Matthew Terry?
Yes, I do.
Do you see Mr. Terry in the courtroom?
Yes, I do.
Could you please point to him and describe what he's wearing so we know exactly who it is you're talking about?
He is sitting over here wearing a gray blazer and glasses.
Your Honor, I'd ask the record reflects to identify the defendant.
Record shall so reflect.
All right. Ms. Rogers, I want to ask, how did you come to know Mr. Terry?
We met on a dating app back in, I think it was May of 2015.
And somewhere after you met on a dating app in 2015, did you all start a relationship?
Yes, we did.
Did that relationship continue through March of 2017?
Yes, it did.
By the time we get to March of 2017, are you and Mr. Terry in what we would call a boyfriend-girlfriend kind of relationship?
Yes, we were.
And were you living together?
Yes, we were.
There's a home at 626 Worthington Drive in Lansing, Michigan. Is that the home where you resided?
Yes, that's correct.
And did you reside there with Mr. Terry?
Yes, I did.
I want to specifically ask you about Friday, March 17th, 2017. Was that a holiday?
Yes, it was St. Patrick's Day.
And for St. Patrick's Day, did you and Mr. Terry have any plans set together as a couple?
Yes, we did.
What were the plans?
The plans were to meet up with a few of his friends and go out to celebrate St. Patrick's Day by drinking.
All right, so your plan was to go out during the day and go have some beers, hang out with friends, things like that.
Yes, but not to stay out too late.
That day, did you end up going through with the plan and going out with Mr. Terry?
Yes.
And what time of day do you think you went out and started hanging out and drinking?
So we started around lunchtime. It was around noon, 12:30, and we met at a place called Clauda's Irish Pub, and we had lunch and drinks there.
And did you all stay out the remainder of the day celebrating, drinking, hanging out with friends?
The majority of the day, not the whole day.
When did the day start to wrap up for you?
I believe it was around 6 o'clock. It was just starting to get dark.
And I want to ask you, during the day, are you drinking?
Yes.
What are you drinking?
It was different at each place. At Clauda's, where we started, I believe we each had a beer, and then we split a beer there along with lunch. And then we moved to another bar called Tavern and Tap, and we had, another beer and I think shots there as well. And then moving to another place later on where I only had water.
Okay. So you kind of talked about it, but Mr. Terry is drinking throughout all of this?
That's correct.
Both beer and liquor?
Yes, from what I remember.
And so somewhere when the day is starting to wrap up for you, somewhere around 6 o'clock, did you have a chance to see Mr. Terry?
Before I left, yes.
And can you describe his condition at that time in terms of how sober or not sober he may have been?
When I found him, it was in an adjacent bar that was completely empty. So I went in there, and he couldn't even speak English. He was slurring his words so bad. He was just talking nonsense and was stumbling all over himself at that point.
All right. And did you tell him you wanted to go home at that point?
Well, I did, yes, but I left without him because I was upset at his condition.
Okay. And so you end up leaving the bar and going home on your own. Is that somewhere around 6 o'clock-ish?
That's correct.
So at some point, do you see Mr. Terry again later that evening?
Yes, I do.
In between that time, have you been drinking?
Not in between that time, no.
And what time do you think it is roughly when you see Mr. Terry?
It was dark by that point. I would say 9 o'clock, 8 o'clock, 9 o'clock.
Okay, so it's been a couple hours at least.
Mm-hmm.
Is that a yes?
Yes,
When he comes, I guess you see him back at the house, correct?
correct.
Describe how he comes home and what happens when he comes home. Tell me what he's like at that point.
So he didn't come to the front door. He came to the back door, which was right off of the kitchen, the sliding door, and he knocked at that door, and I proceeded to let him in. At that time, he was very clearly drunk. He couldn't walk straight. He seemed just very, it's hard to describe, but just you could kind of sense his energy as being very frustrated or angry or upset, just in general, just a
Right.
general sense.
So as the kids say, you got a vibe off of him that he seemed angry?
Correct.
Did you do anything in that moment?
I did not. I went and I sat back down on the couch where I was when he showed up.
And what does he do?
So he went into the kitchen, and I believe he was making a sandwich. He was making some kind of food at the counter, and the kitchen and the living room area is pretty open. So as I was sitting on the couch, I could see him.
And just to help the jury picture that, if you're sitting in your living room, can you see into your kitchen?
Yes, it's an open layout.
It's like an open concept kind of thing?
Yeah, with just the counter dividing the living room and the kitchen.
Right, so you can see him in the kitchen and he can see you in the living room, and tell us what happens next.
So I remember sitting on the couch watching TV, and then, the next thing I remember is standing behind the couch, and I'm looking at him in the kitchen, and I remember him coming around the counter and coming at me.
And before we get to the part where he comes at you, do you remember if you guys are having any sort of argument, if anything's being said, either he's saying something, you're saying something, whatever the case may be?
I don't recall any of that, no.
So you remember now all of a sudden there's a moment he's coming at you, and I want you to describe that as best as you can. Do you mean he's just leisurely walking in your direction?
No, he was coming at me very quickly and aggressively, to the point where I kind of backed off and braced myself, and I actually verbally said, what are you doing? Oh my God, what are you doing?
And when you said the words to him, what are you doing, what, if anything, did he do?
He proceeded to knock me into the front door that was behind me, and at that point then we both fell to the floor.
All right, do you mean he makes physical contact with you somehow?
Correct.
How does he physically contact
Just with
you?
his body, like just taking his whole body and pushing it into me.
And at that point, do you say anything to him?
I don't think I said anything at that point, no.
All right, so what happens next?
So then we're on the floor, and he's just trying to keep me on the floor, and he keeps punching me wherever he can find access to punch me, so whether it be the face, the chest, the back, wherever. And he was a wrestler, and the best way I can describe what he was doing is trying to keep me in wrestling moves and keep me on the floor so that I couldn't escape.
When you say he's a wrestler, you mean like in the WWE, or you mean like a high school coach?
A high school coach, or a coach. Maybe it wasn't high school, but he was a wrestling coach. And I can't remember if he wrestled himself, but.
So you guys are now on the floor near the front door, and there's a fight happening on the floor. At any point, do you say something to him to try and diffuse this situation?
Yes. So as the struggle continues and I'm trying to break free, there was a point when I yelled at him. I said, I love you. Why are you doing this? And he said, no, you don't. Fuck you. I'm going to kill you.
All right. And do you remember those words specifically? No, you don't. Fuck you. I'm going to kill you.
I will never forget them. Yes, I remember.
So tell us what happens next in the fight.
He just continues to, for lack of a better phrase, beat the shit out of me. And I keep trying to escape. There is a point where I'm able to stand up, and he continues to punch me in the face. At one point, he gets me onto the floor, and...
Are you still in the same place by the door, or has the fight moved?
Nope, it moved through the living room, and then where I landed on the floor was, I landed face first. With my upper body like on the kitchen tile, and then my lower half was on the carpet of the living room. And at that point there was blood everywhere.
Where is the blood coming from?
I believe my nose. At that time he had broken my nose. But I remember trying to push myself up, and he was on me, and every time I tried to push myself up I couldn't grip on the floor because there was so much blood. And he would purposely put his weight on me and push me back down, so I was unable to get up.
And through all of this, are you fighting, resisting, trying to stop him?
Yes.
So what comes next?
So I remember laying there, and I was laying on my left side, and I remember seeing the trash can there. There was a black trash can, and at this point he was taking both of his hands, and he was taking my head, and he was slamming it into the floor. And so every time he would do that, my vision would go black. And I thought he was going to knock me out, or I would be unconscious or something at some point.
At some point, does there ever come a moment in the fight where there's sort of a break in the action?
Yeah, so after that, there was a time that he got up off of me for a short time, and I was able to sort of sit up on the floor. And I remember just kind of having my head down and just... I was thinking like, holy shit, that, is this really happening? And I was really disoriented and dizzy, and I was hearing all the shuffling in the kitchen. And then the next thing you know, Mr. Terry comes around behind me and stabs me in the neck.
When you say he stabs you in the neck, do you know what he stabs you with in the neck?
I didn't see it, but it was a knife.
All right. And when you heard the shuffling in the kitchen, do you keep knives in the kitchen?
Yes.
So looking back now, when you hear the shuffling noise in the kitchen, is it the sound of someone rummaging in the kitchen,
Yes.
looking for something potentially?
Sorry, yes.
All right, so now you are still seated on the floor, and I want you to describe your position and his position at the moment when you feel something plunged into your neck.
So again, I'm sitting on the floor, and I'm kind of just, again, disoriented, just kind of sitting, with my hand and my head in my hand. And then he comes around behind me, and he wraps his arm around my neck, and he stabs me in the throat with a knife.
So he's stabbing you from the back,
Yes.
wrapping around you to strike.
Yes.
At that moment, are you armed?
No.
Are you even standing up to put up a fight?
No.
So now he stabs you in the neck with something, which you assume is a knife. What happens?
So at that point, again, it was just kind of the thought, like, holy shit, he just stabbed me with a knife. Like, I need to get the hell out of this house, or I'm going to die in here. And so I remember standing up, and as I stood up, he continued to, try and stop me and try and punch me. I was able to get loose for enough time to be able to turn around, and directly behind me there was the garage door. So I was able to get the garage door open and run to the garage.
All right, now you're in Lansing, so I'm guessing homes might be laid out a little different, but is there access from inside your home to the garage?
Yes, there's a garage door that goes into the garage.
All right, well, we have those here in Florida too, so that's not so different. But at this time of the year, in March, is it snowing in Michigan?
There was a light blanket of snow on the ground at this time, yes.
All right, so you now make for the door to the garage, And as you step into the garage through the door, is there a garage opener?
Yes. So I pushed the opener with my left hand as I was running out to try and get the garage door to open so I could escape that way.
And did the garage door start to open?
It did. And I ran towards it, but it was very slow. So I couldn't quite get under it right away before he was able to get to me again.
All right, so now you're waiting for the garage door open enough, and he attacks you again?
Yes.
Describe how he's attacking you again.
He was just trying to stop me from leaving, and we both fell to the ground at that point and somehow had rolled out of, the garage that was open down the driveway.
So now you've spilled out onto the driveway, like out in public.
Correct.
And what's happening there?
So we were rolling down the driveway a bit, and I ended up in a position where I was under him, and he was on top of me. He had used both of his hands to take my head and slam it into the cement multiple times. Sorry. So he had the knife, and he had stabbed me 3 times in the right shoulder.
All right, so he's still armed with this knife, even though you fled out of the home and he's chased you.
Yes, and this entire time I'm screaming for someone to come help me.
At any point, do you realize that some sort of like neighbor or person nearby has responded to your calls for help?
Yeah, as I was screaming, I could very faintly hear voices across the street saying, get off of her, and just hear them talking. A lot of it I couldn't make out what they said.
All right, and so we're at a point where Mr. Terry and you are in the driveway, you're still fighting, he's still armed with a knife. Tell me what else he's doing and what you're doing in response.
So again, I'm screaming this entire time, that he's going to kill me and somebody please help me. But he had stabbed me those 3 times in the shoulder, and he went to bring the knife down again, and I had reached up and I grabbed with my right hand the blade end of the knife in midair, and don't ask me how I did it. I just grabbed, and I took the knife and I pulled it. Again, I'm on my back, and I pulled it across my face, and I just remember thinking he was going to like stab my eye out or something as I'm doing this, but I was able to pull the knife enough over that it fell out of his hand, and it fell to my left side. And then I kind of rolled over it and tucked it underneath me so that he didn't have access to it anymore.
And so once you've kind of tucked the knife under your body, rolled onto it, does he stop fighting with you, or does he still keep trying to get the knife?
No, he was still slamming my head to the floor, and he would reach down with his hand, and he would try and like fish for the knife real quick, but then I would try to get up, and then he would hold me back down again, and then kind of just back and forth, like trying to fish for the knife, and I'd get up, and he'd try to fish for the knife, and then he'd push me back down. And there was a point when he had gotten really pissed off because I was kind of holding the knife with my arm as it's tucked under me, and he reached down and he bit me on the forearm here to try and get the knife loose from my grasp.
Is that the only place he bit you?
No. Shortly after that, after he fished a couple more times for the knife and couldn't get it, he reached down and he bit me twice on the side of my left cheek to try and get me to let go.
And throughout all of this, are you screaming and yelling for help, asking him to stop, putting up resistance?
Yes.
So does the fight sort of end at some point?
Yeah, so we didn't live that far from the hospital and stuff, and as the neighbors were, I later found out they were on the phone with 911 at the time. We could hear sirens coming. You could hear them coming from around the corner, not too far away, and when we both heard the sirens, that's when he got up off of me and ran back in the house.
And what did you do?
I got up and I grabbed the knife so he couldn't get it back again, and I couldn't see very clearly because my contacts were in, but they were all like covered in blood. But I ran across the street to the voices of the neighbors who were telling me to come over there, come here. And then I proceeded to go across the street, and I collapsed on my back in their front yard.
And where was the knife when you went across the street?
I'm not sure where it landed, but I remember when I fell down, I threw it so that if he came back, he wouldn't find it.
So you carried it with you away from the driveway to wherever it is you ended up in the yard of the neighbors?
Correct.
At some point, did law enforcement come and respond, and emergency medical people respond and end up taking you to the hospital?
They did.
Your Honor, if I can approach the witness. I want to show you, ma'am, what's been marked as states 67A through H.
Yes.
Did you have a chance to look at these earlier?
I did.
Do these photos fairly and accurately depict the injuries that you suffered in the fight with Mr. Terry?
Yes, they do.
Your Honor, at this time, I'd move into evidence states exhibit 67A through H.
Other than previously discussed, any objections at this time?
None other than previously discussed.
All right, they'll be admitted.
Permission to publish, Your Honor?
You may vote.
Ma'am, I'm going to show you 67A. Is this you in the hospital?
Yes, it is.
You are not wearing makeup, right?
No.
Okay, so the discoloration around your eyes, is that bruising?
Yes.
I want to draw your attention over here to what is your left shoulder, but in your picture it's on the right side. Is this an injury you suffered from one of the knives that stabbed into you?
Yes.
I'm going to show you state 67B. I want to draw your attention right here to the almost dead center of your neck. What is that?
A stab wound.
Is that the stab wound that you talked about when he came behind you and stabbed you in the neck?
Yes.
Obviously here this has been stitched up, but at some point that was an open gaping wound, I assume?
Yes.
Here's State's Exhibit 67C. What are we looking at here?
That's my right eyebrow where I was stabbed.
Here's State's 67D. What are we looking at here?
My right cheek and another stab wound.
Here's State's 67E. What are we looking at here?
Another stab wound on my right cheek.
Here's State's 67F. What are we looking at there?
It's my left cheek, and those are the 2 bite marks that he left on me.
Here's State's 67G. What are we looking at here?
It's another stab wound.
And then finally, here's State 67H. What are we looking at here?
Those are the 3 stab wounds to my right shoulder that I mentioned.
Ma'am, all of these photos that we see are generally, I would describe them as sort of like your shoulders and up, kind of your collarbone area and up. Is that correct?
Yes.
All of the attacks that you suffered from the knife, or I guess the bite wound too, but really the knife is what I'm interested in. Those are all to your shoulders, neck, and face. Is that correct?
Correct.
Pass the witness, Your Honor. Cross-examination.
Good morning, Ms. Rogers.
Good morning.
There are parts of this night that you don't remember, correct?
Only the reason why he came at me.
Right. You don't remember what actually started this incident, correct?
Correct.
But you have memory of everything else that you claim occurred, but not what actually caused and started this to occur, correct?
Correct.
You know your blood alcohol level was 0.124, more than 1.5 times the legal limit that night?
I don't know the exact number, but I was drinking, so
You weren't just drinking, you were intoxicated, right?
I don't know what number considers, what number makes it me intoxicated versus drinking, but
Well, if
I was drinking.
If 0.08's intoxicated legally and you're at 1.5 times that, you'd agree that's intoxicated, right?
Yes, if that's the level.
Okay. And it wasn't just beer, you were drinking shots too.
We had, 1 shot.
Okay. And you claimed you left the bar upset, but you weren't upset. You were ticked off, right?
No, I was upset.
Didn't you previously say you were ticked off?
I mean, upset and ticked off are pretty similar.
Okay, so now you admit you were ticked off, is that right?
I was angry, upset, frustrated. Pick a synonym.
Well, upset and ticked off are very different, wouldn't you agree?
No.
Okay, so to you, upset can mean ticked off. You were also pissed off, right?
Yes, all of those are synonyms to me.
Okay, so you admit that you left because you were angry, not just upset, correct?
No, I left because it was time to pick up our child.
Well, speaking of that, you actually stumbled and almost fell down at Matt's parents when you picked up your child, right?
No, that's not correct.
Didn't you previously say that you did?
No, I never said that I did.
Judge, may I approach the witness? July 14th, 2017, page 92. Ma'am, I'm showing you your statement. Please feel free to read as much of the page as you need, but the part is highlighted.
So,
No, you got to read that to yourself
Oh.
and then wait for the next question.
I'm sorry.
Did you have time to read it?
Yes.
Okay, may I have it? Did you previously say, yeah, when asked, do you recall stumbling or almost falling down at their house? Did you say that, ma'am?
Yes, but that's not the latest testimony.
That's right, because you've given multiple versions of what happened. Isn't that true?
No, there was a correction to that statement in the transcript after that one. That is not the latest one.
Ma'am, there's no correction. This is taken under oath. Isn't that correct?
There was a correction to that after the hearing after that. There was a correction to correct that. So you do not have the latest one.
Ma'am, is this a transcript of the July 14, 2017 hearing at the testimony regarding child custody?
Yes, it is. But
So
there was
that's shortly after the incident occurred, correct?
correct. But
And
there was
shortly after the incident
Judge, you still
occurred,
allow the witness to answer the question?
and shortly after the incident occurred, you were specifically asked, do you recall stumbling or almost falling down at their house? Is that correct? Yes or no?
per that, but it's not the latest testimony.
Ma'am,
There was a correction to that statement because they didn't put it
how
down
many
correct.
times have you given various versions of what occurred?
I've testified many times, and there's not been various versions.
Well, there have been actually, because sometimes you said you didn't have shots and other times you said you did. Isn't
No.
that true?
No, we've had shots.
Okay, now you say that. But do you recall previously, and now you're smiling, do you
No, I'm
recall
not.
previously indicating that you had only had beer?
We had beer, and we did have a round of shots.
Okay,
Yes.
now you admit that you had shots too,
I
right?
admitted that the last time we spoke too.
Ma'am, that's because you've talked over and over and over about this incident. Isn't that true?
I've had to.
Okay. Now, in addition to saying that now you're saying you weren't stumbling, but right after you said that you were, you actually then drove home with your son in the car after having been out drinking all week. I'm
Objection,
sorry,
Your
all
Honor. Can we
day,
approach?
correct?
You can approve.
You then drove the infant home, correct?
There was time in between when I left the bar and when that happened, yes.
Ma'am, the question is, did you drive the infant home?
Yes, I did.
Thank you. Now, after that, you actually asked for over $250,000 in damages for this incident, didn't you?
No.
You didn't.
No.
Can I approach?
And Judge, we should approach first so I can show it to counsel. May I approach the witness?
Well, start over.
Certainly.
Ma'am, it is true that you asked for over $250,000 as a result of this incident you described, correct?
No, that's not correct.
May I approach?
Amen.
Do you recognize this?
Yes, I do.
You prepared that, didn't you?
When I was initially
Yes,
asked,
did you prepare that? Yes or no?
this is an initial document, and yes, I prepared this initially.
And you asked for $256,908.53, correct?
No, that's not the final document.
Ma'am, is that the number at the bottom?
Yes, but this isn't the final document.
Sure, did you end up asking for more later?
No, I didn't ask for near that.
You asked for, let's go through this, $1,506.94 to move to another apartment, right?
I was asked to supply any expenses and...
Did you ask for that?
Yes, I did.
Did you ask for additionally 11 months in rent?
Yes.
Did you ask for 12 months in utilities?
Yes, I was forced to move my home. It was out of my home.
Did you ask for a storage unit?
Yes.
Did you ask for expenses for a moving truck and rental supplies?
Yes, these were all costs that I had to pay due to the incident.
Ma'am, did you ask for lost wages,
Yes.
including lost vacation time that you were actually paid for?
Yes.
Did you ask for a lost bonus check you claimed you were somehow due?
Yeah, because I wasn't working.
Did you ask for estimated future child support?
I did, but they won't allow any of that.
Did you ask for estimated costs of future therapy that you weren't even sure you were going to have at that point?
Yes, I did.
Did you ask for money for a lawyer?
Yes.
Did you ask for transportation, gas, mileage?
Absolutely.
Did you ask for anticipated babysitter fees?
Yes, for the doctor's appointments and things, yes.
Did you ask for anticipated things like martial arts classes, self-defense classes, pain and suffering?
Yes, I did.
And that totaled up to over $250,000, didn't it?
That's not the final document.
It didn't.
But initially, yes.
You did.
Initially, that's not what the final document amount was.
Whenever you want to say you asked for more than $250,000, right?
I did ask, yes.
That's what this is really about, isn't it?
No.
Nothing further. Okay.
Ma'am, are you getting paid to be here today?
No.
Are you going to make money from being here today?
No.
The defense keeps asking you about this $250,000 that you asked for, and you keep saying that was not the final thing. I'm just going to ask you, did you get money?
I think he was ordered to pay me, I think, $13,000, of which I've only seen like 1,000
Okay.
before he was incarcerated.
So you got $1,000. That's what you got for this.
Correct.
When she keeps saying $250,000, was that $130,000 you were asking for child support for the child you shared in common?
I don't remember the amount exactly, but yes, we share a child in common.
And Judge, when there's a moment, could we approach?
Sure. Well, why don't you approach now? members of the jury are present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. I know I said it would be brief, but Deputy Estea told me you all were asking about a break. So rather than bring you right back in and then send you back out for a break, we decided to just take the break then. So we'll probably go up until the lunch break from this point forward, but we are going to pick up where we left off. Mr. Diaz, you may continue.
Ma'am, when we left off, we were talking about the money that you asked for. I think we covered that. So I just want to ask you, you were asked about your level of intoxication, and obviously the number, I guess, that you tested for was higher than what would be in the state of Florida, 0.08. That's the level of intoxication in Florida. You understand that?
Yes.
Okay. Even given that you were intoxicated, were you attacking Mr. Terry, that he had to go arm himself with a knife and then defend himself with a knife?
No.
Were you in a fighting position when Mr. Terry stabbed you in the neck with a knife?
No.
Were you chasing him, or was he chasing you when you were trying to flee from the home?
He was chasing me.
Was he the one that was stabbing you with a knife?
Yes.
Did you ever stab him with a knife?
No.
How many other questions, Your Honor? Thank you.
May this witness be released by the state?
Your Honor, she's released for purposes of today.
All right. So she can step outside the defense. Do you need her to stick around today for anything?
No.
All right, ma'am, you may step down. You're released for today.
Thank you.
And I will ask the state to please call your next witness.
The state of Florida calls Detective Matthew Crumbach.
Krumbach?
Crumbach, K-R-U-M-B-A-C-H.
Detective Krumbach, good morning and welcome, sir.
Good morning.
You'll come forward to be sworn, and before you're sworn, I do have a brief instruction that I need to read to the jury. Ladies and gentlemen of the jury, I'm going to read you the instruction again. The evidence that you are about to receive concerning other crimes, wrongs, or acts allegedly committed by the defendant will be considered by you for the limited purpose of proving intent, identity, or the absence of mistake or accident, and you shall consider it only as it relates to those issues. However, the defendant is not on trial for a crime, wrong, or act that is not included in the indictment. Detective, if you'll raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Thank you. If you'll follow the bailiff now to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjustable.
Thank you, sir.
You let me know when you're ready, and then I'm going to allow the attorneys an opportunity to ask you some questions.
I'm ready.
You
Thank
may
sir.
proceed, Mr. Diaz.
Thank you. Sir, if you would, please introduce yourself to the jury.
Hello, I'm Matt Crumbach. I am a retired detective with the City of Lansing Police Department.
And what do you do currently?
I currently work for the Michigan Commission on Law Enforcement Standards, which is the licensing and regulatory agency for all police agencies and police academies in the state of Michigan.
You mentioned that you're retired from Lansing PD. When did you retire?
I retired 1.5 years ago.
And when you retired then somewhere around 2020, how many years did you have on the force?
I had 25 years.
During the course of your 25 years on the force, did you ever serve as a detective?
Yes, sir, I did.
Specifically, did you ever serve as a detective working in what is called a homicide unit or murder investigation unit or major crimes unit, something like that?
Yes, sir, I did.
How long were you in that unit?
8 years.
During the time that you were in, I'm going to call it the homicide unit, when you were in the homicide unit with Lansing PD, were you the detective who was assigned to a case involving a victim named Michelle Rogers and a suspect named Matthew Terry?
Yes, sir, I was.
And do you see Matthew Terry here in the courtroom?
Yes, I do.
Could you please point to him and describe the clothing that he's wearing so we know who it is you're talking about?
He's a subject sitting in the middle. He's wearing dark framed glasses and a blue tie and a white shirt.
Your Honor, that's the record reflects to identify the defendant.
Record shall so reflect.
All right, so this investigation, is this tied to March 17th of 2017?
Yes, sir, it is.
And specifically for residents at 626 Worthington Drive in Lansing, Michigan?
Yes, sir.
You were not one of the first responding officers, correct?
No, sir, I was not.
But at some point, did you become the lead detective on the case?
Yes.
as the lead detective on the case, did you respond to the scene?
Yes, sir, I did.
And did you have a chance to walk the scene as it was at 626 Worthington and at the neighbor's house across the street in the front yard area?
Yes, sir, I did.
Detective, I'm going to show you what's been pre-marked as State's Exhibits 68A and B. Do you recognize these photos?
Yes, sir, I do.
And do these photos fairly and accurately depict a portion of the scene as it was at 626 Worthington and across the street at the neighbor's house?
Yes, sir.
Your Honor, I'd move into evidence State's Exhibit number 68A and B.
Other than previously discussed, any additional objections at this
Not,
time?
not other than previously discussed.
All right, they will be admitted.
All right, so Detective, I want to first talk with you about the interior of 626 Worthington. Did you have a chance to go inside the house?
Yes, sir, I did.
I don't need to get into all the gory details, but just as a general question, did you see signs of struggle actually inside the residence in the areas of like the kitchen and near the areas of the living room?
Yes, sir, I did.
Did you see signs of struggle in the residence in the door that would go from the kitchen area into the garage and in the area of where the garage door opener would be?
Yes, sir, I did.
Did you see signs of struggle in the area of right where the garage door opens and sort of would connect with the ground between the inside of the garage and the outside of the garage?
Yes, sir, I did.
And did you see further signs of struggle that then would have spilled out onto the driveway of 626 Worthington?
Yes, sir.
Did all of those appear to be an indication of a moving attack through the residence and eventually out of the residence?
Yes, sir.
I want to specifically draw your attention to 68B. Do you recognize what this is?
Yes, sir, I do.
And did you personally see this?
Yes, sir, I did.
As part of this investigation, were you under the belief, or at least working from the theory, that a weapon had been used,
Yes, sir.
specifically a knife?
Yes, sir.
Did you take the time to go and inspect this knife block in the house?
I did.
And I'm going to zoom in so we can see it a little better. It's a little hard to see, but there appears to be spots in the knife block where knives are missing. Did you observe that yourself?
Yes, sir, I did.
Were there two knives missing from the knife block?
There were.
Was there a knife found in the yard across the street at the neighbor's house?
Yes, sir.
Did that knife match these same knives that are black handled with these sort of silver or chrome tips at the end?
They are, sir.
I'm going to show you State's Exhibit A, 68A. Is this the knife that was recovered from the neighbor's house?
Yes.
And is this knife consistent in appearance with the knives that we just saw in State 68B that had at least one or two knives missing from the block?
It is, sir.
Is this the area where Michelle Rogers was ultimately found by first responding officers when they came to render aid?
Yes, sir.
I don't have other questions, Your Honor. I'll pass the witness.
Can we
provide me the site because I didn't scribble it down.
For this witness.
All right. May this witness be released by the state?
No, Your Honor, he's free to go for today, but.
Okay.
not released.
All right. You may step down at this time, Detective.
Thank you, sir.
You're welcome. Mr. Diaz?
Your Honor, at this time, state of Florida rest.
Ladies and gentlemen of the jury, the state having rested their case, there's some things that I need to talk to the attorneys about, so I'm going to send you out before we turn to the defense. I'm not sure how long this break is going to last. If I determine that the break is going to last a lengthy period of time, I'm going to go ahead and give you a early lunch, but a long lunch. I'm just not sure, and I'm going to go ahead and send you out for purposes of me discussing that. So please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case. All rise for the jury. Jury has exited. Everyone may be seated. Well, we're at the point where the state has rested, so I suspect that the defense wants to be heard. But before we, I mean, right?
Yes, of course.
Okay. Before we do that, though,
Judge, just in regard, before we get to that part.
Okay.
Just in regard to Detective Crumbach's testimony, I just want to make a proffer of what we would have asked him had the court allowed me to inquire without it opening the door to the defendant's convictions.
I'll allow it.
What I would have asked was, you are aware that at a prior hearing, Mr. Terry actually gave his version of what occurred that night. You're aware that what he said was that Michelle Rogers smacked him across the face twice. She punched him, and they ended up on the ground wrestling, correct? I would have then asked him, he also indicated that Michelle had a knife in her hand and started swinging at him from 2 to 3 feet away. I would have also asked, Matthew Terry testified that she had to be taken to the ground. He kept telling her to put the knife down, and that he rolled off of her once she stopped struggling with him. I would have also asked Detective Crumbach that Matthew Terry had said that Michelle had the knife in her hand and tried to stab him from 2 to 3 feet away, which is what caused him to have to grab her wrist. He pushed Michelle Rogers away and said that when he couldn't see the knife, he let Michelle get up. Isn't that correct? I would have further asked Detective Crumbach that Matthew Terry said that he saw that she still had the knife in her hand, which is when he had to grab her wrist and her hair because he couldn't grab a hold of her shoulder, and that he was trying to knock the knife out of her hand, correct? I would have further asked Detective Crumbach that Matthew Terry indicated that they were struggling and rolling down the driveway, and that those incidents and those specific facts are how she ended up getting her injuries. Isn't that correct? I would have also asked that he heard Matthew Terry indicate that the stabbings occurred as Michelle was pushing the knife towards him and he was pushing it back, which is why she ended up getting stabbed in her shoulder 3 times. Isn't that correct? Because of the ruling, obviously.
Well, and I want to make it clear that I did not rule. The state was objecting to those questions as hearsay, and I had not yet made that ruling, but I did rule that if we got past the hearsay issue and I allowed those questions to elicit that testimony, that would open the door to Mr. Terry's prior conviction in that case. So I did make a ruling on that, and it's my understanding that as a result of that ruling, the opening door to the prior conviction, you decided not to ask those questions and not to seek a ruling from me on whether it was hearsay or not.
Correct, Your Honor.
Okay. All right, so that's on the record. So let's talk just now about what I'm going to do with this jury, whether we should hang on to them for a little bit of time. I know that we have JOA arguments that you would like to make. Then after that, depending on how I rule, not prejudging, but we have to, all the different, I mean, obviously, if I was to grant, or if I was to reduce it to a lesser offense, we would still be going. So, what I want to know is there any other witnesses besides the possibility of Mr. Terry testifying?
No.
All right. Let's hold, though, on me inquiring with him as to whether he wants to testify, because I think we need to do the JOA before I do that.
And we'll need a break somewhere private for maybe 10
Right.
minutes before we can give you that answer.
How long do you anticipate the JOA arguments to last?
Short.
Okay. All right. Well, let's proceed.
At this point, Your Honor, the defense would renew all our previous motions and objections, specifically the two motions for mistrial, the objections to state witness evidence, and the Williams rule, in addition to the statement in the medical records that we objected to prior to their introduction, and our objection to the jury panel as a whole. The defendant in this case, Mr. Terry, is only charged with one count of premeditated first-degree murder. I provided, Your Honor, several cases in the state prior to the judgment of acquittal argument. The testimony that we've heard so far has basically been circumstantial evidence related to what went on and transpired prior to Ms. Baker's death, that Mr. Terry and Ms. Baker were out that evening, that they lived together, they had gone out to the Landing Bar, and then there had been some kind of disagreement there based on the witness testimony and the text messages. And the last text message from Ms. Baker's phone that the state introduced is that all is good now. When the 911 operator was called, the neighbors had found Ms. Baker on the side of the home, and the investigation pursued from that point. There's been no direct evidence related to Mr. Terry being the person that committed those injuries. A weapon was not obtained. There's been no statement from Mr. Terry admitting his involvement in this case. And so the two areas that I'd ask the court to focus on is the circumstantial evidence. I outlined Hodgkins v. State, Hodgkins v. State 175, Southern 3rd 741. That's a Florida Supreme Court 2015 case. That indicates that there's a special standard of review of the sufficiency of evidence applies where a conviction is wholly based on circumstantial evidence, where the only proof of guilt is circumstantial. No matter how strongly the evidence may suggest guilt, conviction cannot be sustained unless the evidence is inconsistent with any reasonable hypothesis of innocence. It also goes and outlines in State v. Huntley, 310 Southern 3rd 418. It's a 4th DCA case from 2021. And that case cites Graham v. State 748 Southern 2nd 1071, which is another 4th DCA case from 1999. And it outlines that the law guards against an impermissible stacking of inferences. An impermissible pyramiding of inferences occurs where at least two inferences in regard to the existence of a criminal act must be drawn from the evidence and then stacked to prove the crime charge. In that scenario, it is said that the evidence lacks the conclusive nature to support a conviction. And our argument would be that that's what we have in this case, is a stacking of inferences used to try to show that Mr. Terry is responsible for Ms. Baker's death. We would also attack the element of premeditation. Premeditation is the essential element which distinguishes first-degree murder from second-degree murder. And I provided to the court Balzort v. State, which we've referred to a lot, related to the Williams rule argument. And that's 75 Southern 3rd 830. That's a 2nd DCA case from 2011. And that case also cites to Berube, B-E-R-U-B-E, v. State, 5 Southern 3rd, 734. It's a second DCA case from 2009. In that case, in Balzord, along with the Williams Rule arguments, it talks about premeditation, and that premeditation is a fully formed conscious purpose to kill which must exist for a sufficient length of time to permit reflection as to the nature of the act to be committed and the probable result of that act. Premeditation may be proven by circumstantial evidence. However, where the element of premeditation is sought to be established by circumstantial evidence, the evidence relied upon by the state must be inconsistent with every other reasonable inference. Where the state's proof fails to exclude a reasonable hypothesis that the homicide occurred other than by premeditated design, the verdict of first-degree murder cannot be sustained. Now, in Balzord and Berube, both of those are strangulation cases, but I brought to the court Poulin v. State, which is 696 Southern 2nd, 738. That's a Florida Supreme Court 1997 case, which involves a stabbing similar to the allegations in this case. And in that case, the defendant and the victim had been hanging out and drinking with a group of people. It also involved an argument, and later the victim was stabbed to death. The court in that case found that although the evidence is consistent with an unlawful killing, they did not find sufficient evidence to prove premeditation, and they reduced the charge to second-degree murder. So based on those arguments, we would argue that based on the impermissible stacking of inferences, the court should grant the judgment of acquittal. But if the court does not find that argument persuasive, we would argue against first-degree murder in relation to premeditation and argue that it should at the very least be reduced to second-degree murder.
All right, thank you very much, Mr. Pratt. Mr. Diaz, response from the state?
Your Honor, Mr. Dirks is handling this one, state.
Your Honor, the defendant argues that this is a purely circumstantial case, and the state would submit that that's far from it. The evidence shows, as has been outlined, the court's well aware of, that we have the evidence of the defendant and the victim being together a matter of minutes before the murder occurs. They were out together. The argument that ensued has been discussed. They arrived at home together. The evidence further shows that direct evidence, not circumstantial evidence, shows that the defendant's DNA is under the left fingernail of Kay Baker. On the north side of the fence, the green U marker, the court went through the DNA, it understands the DNA. There's obviously a struggle. The evidence, the direct evidence of the DNA shows that there's a struggle outside in the blood of the defendant and the blood of the victim in a couple places together. That direct evidence shows that evidence of the struggle. So this isn't a circumstantial case at all. There is direct evidence that accompanies the circumstantial evidence. And so we dispute that this is an exclusively circumstantial case. Having said that, the cases cited by the defendant have been overruled. Since May 14th, 2020, that argument that the circumstantial evidence, again, we dispute, must be inconsistent with every reasonable hypothesis of innocence. That special instruction in first-degree murder cases has been overruled in Bush v. State, cited at 295 Southern 3rd, 179. So essentially, the circumstantial evidence rule now that exists is just like every other case. The court must determine whether or not that, based upon all the facts and circumstances, with the evidence viewed in a light most favorable to the state, whether a reasonable jury could conclude that the defendant is guilty of first-degree murder. given those facts and circumstances regarding the defendant and the victim having been in a dispute, being together, the only persons that were in the company of each other were the defendant and the victim, by the evidence, just minutes before the murder takes place, all the DNA evidence that was presented, which I don't need to recount, the manner in which the murder occurred, the multiple stab wounds, the defensive wounds, the extreme nature of the injuries that were incurred, the fact that the defendant was found hours later hiding nearby the murder scene. The cases cited by the defendant are nothing like these cases, this case that we have before us now. For all those reasons, Your Honor, both by the facts and the law, the state would request the defendant's motion for judgment equivalent be denied.
Thank you, Mr. Dirks. Anything else, Ms. Bradley?
No, Your Honor.
All right. I do note that all of the cases relied upon by the defense are pre-Bush. I do believe that the law in Florida has somewhat, if not significantly, changed since the Supreme Court's decision in Bush. And as to all of the arguments, including the circumstantial evidence, the stacking of inferences, and the premeditation, I am going to deny the defense motion for acquittal at this time and request alternatively to reduce the charges from the first-degree murder. I believe that it is a jury question, and I am going to deny the JOA at this time, as I said.
Judge, I'm sorry. I know I said I don't have anything further, and I'm not disturbing your ruling, but I just did want to put on the record
Absolutely.
that related to Bush, I did provide the court with State v. Huntley, Huntley, which is a 4th District Court of Appeals case from 2021, which also refers to the Bush case. It is a case that I provided to the court in the state that talks about Bush and how the stacking of inferences may evolve, but it still goes back to impermissibly stacking inferences related to Graham v. State, 748 Southern 2nd, 1071. So I did provide that to the court. I just don't want the record to seem like I'm giving you cases that are outdated, because I did give you this one.
No, I see that.
Addresses that issue.
And it does cite Bush, and it does talk specifically about the stacking of inferences, and I am aware of it, but I am going to deny the motion. I appreciate that, though. So that takes us to defense case, and I know that you indicated that you would like some time to talk to Mr. Terry, which I'm absolutely going to grant to you. Additionally, you've indicated there are no other witnesses, so once you've talked to him and then I discuss with him and we decide he decides actually whether he's going to testify or not, we'll know then what the next step is. And how long would you like?
If you could just give us 10 minutes, maybe we could go in the holding area so that we can have some privacy.
Yeah, let me. I will do that, and I will instruct the bailiffs to assist you with that.
Thank you.
All right. So we'll be in recess for 10 minutes. Thank you. Reflect everyone is present now, including Mr. Terry. Ms. Perry, have you had an opportunity to discuss with Mr. Terry his decision whether to testify or not during his case in chief?
We have, Your Honor.
Is he prepared for me to address him and ask him questions regarding his decision?
He is.
All right. Mr. Terry, all right, that's fine. If I do need to swear you in, if you'll raise your right hand, please. Do you swear or affirm any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and put your hand down. Sir, this is the time in your trial where you have a very important decision to make. That decision is whether or not you are to become a witness in your case and testify before this jury. You may have heard me tell the jury in the beginning, in the initial instructions, that you are not required to testify and that they cannot hold it against you if you don't. In fact, there is another instruction, if you decide not to testify, where I will tell them that you've exercised a fundamental right by choosing not to be a witness, and that they are not to view that as an admission of guilt or be influenced in any way by your decision. It ultimately says no juror should be concerned that Matthew Terry did not testify at trial. I will only give that instruction if you do not testify. The other side of that decision is you have an absolute right to testify. I would bring you just as other witnesses, swear you in front of the jury. You would take this stand here. Your attorneys would have an opportunity to ask you questions first, and the state would have the opportunity to cross-examine you. Then your attorneys would have the opportunity to re-examine you, redirect. This decision is your decision and your decision alone. However, it is very important that you discuss your decision with your attorneys. So my first question to you, sir, is have you had sufficient time to discuss this very important decision with your attorneys?
Yes.
One thing that I left out, if you take the stand, then because you have a prior conviction, that is something that would come out. And I don't want to know what you've talked about with your attorneys. I suspect that you've talked about that with them, but I want to make sure on the record that I've made you aware of that if you take the stand, then the state or the defense would bring out the prior conviction that you have in the Michigan case. And it's my understanding, and I'm going to verify with the state at this time, that that's his only prior conviction. Is that correct?
That is correct. Well,
All
he
right.
has some misdemeanors, but they don't.
Okay, they don't satisfy the statute. So there's just the one prior conviction, but it would come out if you decide to testify. So that's one of the many things that you should take into consideration. Let me ask you again, have you had sufficient time to consider whether you want to become a witness or not?
Yes.
Have you made a decision?
Yes.
What is your decision?
My desire is to testify. However, I am going to follow my attorney's advice and not testify. Therefore,
Well-
I will not be testifying.
Well, need to be very careful here. Do you understand? I encourage you to consult with your attorneys and to consider their advice. But at the end of the day, it is your decision and it is not their decision. Do you understand that?
Yes, I have decided to follow their advice and to not testify. That is my decision.
Okay, so after consulting with them and discussing whatever you may have discussed, again, I don't want to know, you have made a decision, and your decision is not to testify.
Yes, however, my desire hasn't changed. But again, I am going to follow their advice.
Well, I have a couple more questions that I ask anyway, but they may be even more important now, and that is whether or not anyone has forced you or threatened you in any way to make this decision.
No.
Are you under the influence of any drugs, alcohol, or prescription medication that might affect your decision?
No.
Ultimately, I need to determine whether your decision is freely and voluntarily made. Do you believe that your decision not to testify, in light of everything, including what you've expressed as your desire, is a free and voluntary decision not to testify?
Yes.
Okay. State have any requests of any questions?
No, Your Honor.
Defense have any requests of any questions? Anything to put on the record?
No, Your Honor.
All right, thank you very much. Mr. Terry, you may be seated. So that means that there are no witnesses from the defense, correct?
Correct.
So when I bring the jury in, the defense is going to rest. Is that correct?
Yes, Your Honor.
I suggest it's 11:30. I suggest I bring them in, allow you to rest, then I send them to lunch. Let's talk about how long. We need to do a charging conference, but it looks like we're going to do closing arguments right after lunch.
Yes.
And perhaps even an early lunch. If I send them to lunch at 11:30, I tell them to come back at 1, that's an hour and a half. Is that sufficient time?
No, they're waiting.
Is that sufficient time?
I'm fine.
I don't think there will be a lot of hassling over the jury instructions. We've already resolved some of the typos and things, so I think we can do the.
I didn't anticipate either, but I want to make sure you all have a brief opportunity to have a lunch and then be prepared to give your closing arguments. I did warn you yesterday that this may be happening today.
All right.
So 1 o'clock?
Yes.
All right.
Ask that we do the charge conference before we break for lunch.
Absolutely.
Okay.
Yeah. I just want to get them to lunch. So I'm going to bring them in. It's 11:30. I'm going to send them, tell them to come back at 1. We're going to do the charging conference so that we can get all the instructions printed, handed out, and then 1 o'clock we come back and we do the closing. I'll do the instructions and the closing arguments.
That sounds good.
All right. Let's get the jury. Now, typically I allow you to formally rest in front of me and then ceremoniously rest in front of them. I don't know that that's necessary because I do know that you want to renew all of your stuff. So you're only going to rest once. It's going to be actually in front of them. So it will be the official resting will be in front of them. Mr. Terry, until they say that they rest their case, you can change your mind. So if you want to lean over and tell Ms. Perry that you've changed your mind, I just want to let you know that until the defense says, I rest or we rest, you have the opportunity to change your mind. You understand that?
Yes, sir.
Okay. Might as well stand if everybody else is standing.
It's nice to stand
It is. I agree. I agree, and I usually do. I felt awkward being just about the only one sitting, while everyone else was standing. Yes, we are.
All rise, jury entering courtroom.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. This is one of those times when I take full responsibility for the length of delay. If you're unhappy, please not hold that against the attorneys, the parties, or anyone else. I am responsible for the length of the delay. At this time, though, we are going to turn to the defense for their case. Is the defense ready to proceed? All right, thank you. Ladies and gentlemen of the jury, the state having rested their case and the defense now having rested their case, you may recall from my initial instructions that the next step is the arguments of the attorneys and the instructions on the law. Given the time, I'm going to go ahead and give you your lunch break now. It's a little bit of an early lunch, and I'm going to give you an hour and a half. We're going to come back at 1 o'clock for the final arguments from the attorneys and the instructions on the law, and you will begin your deliberations this afternoon. Please Do not discuss this case amongst yourselves or with anyone else. Please do not do any research related to this case in any way, shape, or form. Please avoid any contact with any outside media, social media, anything about this case. Please enjoy your lunch, and we will see you back at 1 o'clock. All rise for the jury. Jury has exited. Everyone may be seated. Mr. Diaz, you had indicated that you all have talked about the jury instructions. I appreciate that from both sides. My staff attorney was going to pull them up and make any changes that we make during the charging conference.
And yes, Your Honor, Ms. Bradley had pointed out some like typos and things that I have already corrected, so the staff attorney may see that on her copy, but I don't think we made anything.
Well, I want the most recent copy. If you can email that, and I think it'll go through pretty quickly if you email it to her address or what?
Yes, Your Honor, give me 1 second.
Ms. Bradley, did you want to say something?
Judge, I'd also just at this point renew our...
Oh, yes, I do apologize.
It's okay. I will renew all previous motions and objections and renew our judgment of acquittal based on the same arguments and case law stated previously.
Appreciate that, and even at the different standard at this time, same ruling as to all previous motions, objections, and at the renewed motion for judgment of acquittal, even at the higher standard, I am going to deny that at this time. In just a moment, when we have the most recent version of the instructions, we'll go through them. You can give. I don't need a printed. You can give me the other printed copy, though. Let me know when you get it.
Okay.
I appreciate the numbering on the bottom right-hand side. It makes it easier. While is this the version?
Yep.
While she's pulling that up, remind me. It's probably clear on here. Well, I'm actually missing that instruction. There's a closing argument instruction. It's 3 point.
I just interested.
All right. I just want to put it in order. Remind me, though, I know we discussed and had an agreement in the beginning as to whether you were going to do your closings, which is what I believe, and then instructions, or instructions and then closing?
Closings and then instructions.
Okay, that's what I recall. So the language that I have should be consistent with that. And I do have a stack that is 1 through 20. However, that starts with 3.2, statement of charge, and there is an instruction that I believe is 2.7 that goes right before that regarding closing arguments. So that's what I'm looking for.
Your Honor, 2.7 is in the other packet, which is pages 1 through 6. You should have had a packet of like your preliminary instructions and the instructions during trial.
So you want me to add this to this packet?
No, I just need this. I just want to go over and make sure there's no objections. I don't care about in fact, let me verify with the defense at this time. Normally, what I send back to the jury, and I let them know, I don't send back 2.7 unless you want me to. I consider what is now, starting with 3.2, pages 1 through 20, as the substantive instructions on the law. I consider 2.7, which is page 6 of 6, as just a procedural thing, letting them know what's going to happen next. So what I suggest is we just leave that as 6 of 6 and that not go back to the jury. and then we discuss 1 through 20, and this is what goes back to the jury. Any objection to that?
No, Your Honor.
All right. So as to 6.6, let me just make sure, let's go over and make sure there's no objections.
You're saying 6.6, it's 2.7.
6 of 6, I agree. I was looking at the bottom page. 6
Okay.
of 6, 2.7, closing argument. Both the state and the defendant have now rested their case. The attorneys will now present their final arguments. Standard language, any objection?
No, Your Honor.
All right. So we're going to hang on to that. Now we go to the stack that starts with 3.2, statement of charge, page 1 of 20. What we'll do is, what I find to be the most efficient is, Mr. Diaz, they're your proposed instructions. I don't need you to say no objection. However, if you have anything that you want to be heard on or suggestions or anything, you're welcome to do so. But I'm just going to go through with the defense and see if they're in agreement with each of them. So as to 3.2, statement of charge, any objection?
No objection.
As to 3.4, lesser included offense crimes, and we have 2 specific that are listed. Those are second-degree murder and manslaughter. Any objection?
No objection.
No additional requested or any other lesser includeds that you believe should be included?
No, Your Honor.
Thank you. Next, I have 7.1. We're on page 3 of 20, introduction to homicide. It, I suspect, is more than 1 page.
No, it's one.
It is? Oh, okay. You're right. It is 1 page. So page 3. Let me just take a look at it, and then I'll ask. All right. Any objection from the defense?
No objection.
Thank you. Next, I have page 4, 7.2, murder as to count 1, and it includes 3 separate elements. Any objection?
The only thing I would take out is give only
Yeah.
if they're...
Yeah, I see that. So give only if there is evidence that the defendant acted in the heat of passion on legal and
Is the defense asking for the instruction that follows?
I am, Your Honor.
okay.
Is there evidence they're relying on that meets criteria A? There must have been a sudden event that suspended the exercise of judgment in an ordinary, reasonable person. I mean, I don't expect the defense to tell me what their argument is, but all of their argument seems to be someone else committed this crime.
The jury is free to make any reasonable inferences from the evidence, and the state's own evidence and arguments are is about a disagreement that starts in one place and may continue and start again, that they were starting to get to bed and talked about them taking off their shoes. And so obviously the jury is free to infer from the evidence a reasonable inference is that there was some kind of sudden provocation which led to the incident. So we would ask for that.
If the defense wants, I won't object. I'm just very
Okay.
confused. But
Okay, I'm glad.
So just delete the sentence in italics.
But we're deleting the italicized give only if
yes,
there is evidence.
I'm striking that right
Correct.
now on the electronic copy I have here.
All right, well, and as I said, my staff attorney is making those changes, and we can print out multiple copies. I don't know if that's going to bump that all onto 1 page. There's still going to be 2 pages. And actually what I prefer is that last paragraph on that second page not come up, that still remain
That's the last thing on that page.
the
That's
only thing.
Only
on that
thing,
page.
correct.
Okay. All right. So, any objection other than taking out the give only if there is evidence, and I will give the heat of passion instruction. Any objection to that 7.2?
No, Your Honor.
Thank you. Next, I have 3.3a, aggravation of first-degree murder by carrying, displaying, using, threatening to use, attempting to use a weapon. This is page 6. Any objection?
No, Your Honor.
Thank you. Next, I have page 7, lesser included offense as to count 1, which is second-degree murder. It also includes 3 elements.
No objection.
Thank you. Next, I have page 8, which is 3.3a, aggravation of second-degree murder by carrying, displaying, using, threatening to use, attempting to use a weapon.
No objection.
Wait, sorry. Oh, go ahead, sorry. Go ahead.
Okay. Next, I have that was page 8. Next is page 9, lesser included offense, also as to count 1, 7.7, manslaughter. which includes two elements, one with an A and a small b.
Well, we've already agreed, the defense suggested to strike B, so I've already amended it, it's just an A.
Oh, okay, all right, you're right. I don't have the most recent in my printed out copy, but all right. So,
I have it.
other than the elimination of B, is there any objection?
I have no objection to the revised version that was just sent.
And the only difference on the printed out one that I have is the elimination of small b.
And the two paragraphs defining culpable negligence.
Okay. So there's been a change that you all agreed upon. So, Mr. Diaz, no objection?
Yes, we struck culpable negligence as a theory, and then we struck the two paragraphs that deal with culpable negligence.
So let me just look at
Yeah.
it.
Yes. So these are gone.
All right. So the last two paragraphs are gone. Agreed?
Yes, Your Honor.
Okay. Next, I have page 10, 3.3a, aggravation of manslaughter by carry, display, using, threatening to use, or attempting to use a weapon.
No objection.
Thank you. Next is page 11, 3.6d, voluntary intoxication.
No objection.
Thank you. Next is 3.7, plea of not guilty, reasonable doubt, and burden of proof, and this is on page 12 of 20.
Judge, I'm sorry. I don't know if you want to go back to 3.6D and just take out the or she.
I'm happy to. Mr. Diaz, a person is voluntarily intoxicated if he or she knowingly consumed. So take out the or she and just person is voluntarily intoxicated if he knowingly consumed.
Yes, sir, I'm fixing it right
There's
now.
there's two he or she's in that
I got
last
both of them.
sentence.
I got both.
All right. So is my staff attorney taking that out of 3.6D at the request of the defense and the agreement of the state. And me. I like taking that out. So now let's go to 3.7. I don't remember page 12 if the defense indicated no objection. I don't think so.
I'm sorry.
No, I don't think that I've gotten your response to 3.7.
No objection.
Thank you. Next, I have 3.9, weighing the evidence. This may require some revision. It has paragraphs 1 through 11 on my, 12. It's
That's
2
all right.
pages.
And that was an error that we already fixed. Paragraphs 10, 11, and 12 on the copy you have are the same paragraphs that repeated below. For some reason, they got put in twice and numbered. I don't know why that is. But 10, 11, and 12 we've already struck. We only have 1 through 9 left at the moment.
Okay.
The only additional amendment is, I think, number 9 should be removed. I don't think there's been any
I agree.
priors.
Has the witness been convicted of a felony? We'll take out.
And then the defendant in this case has become a witness.
And the capitalized, the defendant in this case has become a witness should also come out. Agreed?
Yes, Your Honor.
Yes.
And that still was on the second page.
I'm not surprised. All right. It's still going to be 2 pages, but you've already eliminated 10, 11, 12. We have now eliminated 9 and the bold part about the defendant becoming a witness. Next, I have page 15, 3.9a, defendant not testifying, which is absolutely now relevant. Has the defense had an opportunity to take a look, check the language on it?
Yes, no objection.
All right. Next, I have page 16, 3.9b, defendant's statements.
I had that in the off chance that Your Honor was going to allow anything from the medical records that was considered a defendant's statement.
Well, I'll see if they're requesting it. Maybe,
Yes.
maybe not.
We are.
All right. No objection to it, Mr. Diaz?
No objection.
All right. And it is good as is? No, does it need any changes?
No, Your Honor.
No, it doesn't need any changes, or no, it's not good as is?
It does not need any changes.
So it is good as is?
Yes, we have no objection.
You know me, I want a perfect record.
You got it.
Thank you. Next is page 17, 3.10, rules for deliberation, includes numbered paragraphs 1 through 7.
No objection.
Thank you. Next, I have page 18, 3.11, cautionary instruction.
No objection.
Thank you. Next, I have page 19, 3.12, verdict.
No objection.
Somewhere, I actually have the verdict. Here it is. It is one page. It's titled Verdict Form Guilt Phase, and then it has choices and parentheses that are consistent with the choices. Check only A, B, C, or D, plus any other specific findings. Defense, any comments, suggestions, objections to the proposed verdict form?
The only thing that I'd ask now, looking at it, is just to remove the portion that says guilt phase. I don't think there'll be any confusion
I
as to
agree.
this verdict
That's
form.
fine.
Any objection? Yeah.
Done.
All right. Anything else?
No, Your Honor.
All right, so we have a verdict form. It does not say guilt phase verdict form. After that, I have 3.13 submitting case to jury. And let me ask you all why it looks so short. It's not usually that short. Has something changed?
I don't know, double check.
Yeah, there's a substantial part of the standard 3.13 that is not included.
I don't know why that is, I apologize.
You see it though, that there's several paragraphs that are missing?
You're completely correct. The first two
Wait,
paragraphs
wait.
are there, and then the rest of the paragraphs are not.
Let the record reflect that Mr. Diaz said I am completely correct. Can you mark that?
Sure, we can have it framed afterwards if you.
I will. I intend to. So now that Mr. Diaz is, well, actually, my staff attorney is pulling up the standard instruction. Ms. Bradley, I'll ask that you pull up so that we can discuss the addition of the other standard paragraphs.
I have it.
Did you not notice that it was short? I know that when I went to you, that's exactly the first thing you were going to say. I give you credit.
I wasn't going to say anything. Miss Bradley, I'm sure, would have mentioned.
I know she would have. I know she would have. Your Honor, it's just not all there. She'd be happy to say Mr. Diaz is not all there.
You always do bailiff, not court deputy, right?
Yeah, bailiff. My staff attorney just asked me, there's some in their language that there's a choice between bailiff or court deputy, and I've instructed her, you have, in the paragraphs that you included, said bailiff, but that is what I
Actually,
used.
at the opening of the trial, you said court deputy is what you said, because you had me change it.
My bad.
So, okay, that's fine. I don't know if you want me to, you don't send the initial instructions back,
No.
right? Okay.
You want bailiff?
Bailiff.
Okay.
Mr. Diaz just wants to point out a mistake I made.
No, I wasn't sure if you were going to send that instruction back, and I had changed it, because you normally say bailiff, and then you said court deputy, and that's what
Right.
stuck out.
So are we ready to discuss the complete version of 3.13? Ms. Bradley?
Sure.
The one I have in my hand only has 2 paragraphs. What is the following paragraph?
It is, many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate.
So that's the 3rd paragraph.
Yes.
4th paragraph is, if you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note.
That's the 4th paragraph.
Next is, if you have a question, I will talk with the attorney before I answer, so it may take some time. You may continue your deliberations while you wait for an answer. I will answer any questions, if I can, in writing or orally here in open court.
That's the 5th.
Then, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations, and then you always do. These exhibits will be sent into the jury room with you when you begin to deliberate.
Any objection to that? Apparently that's a choice.
Yes, no objection to that.
All right. Mr. Diaz, any objection to that?
No objection.
All right.
Give me 1 second. Okay, and then it will just be, in closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share.
So, as to the full version of 3.13, I'm surprised Mr. Diaz didn't blame that on Mr. Gerbs. Is there any objection?
No objection.
Mr. Diaz?
No objection.
So we have jury instructions. We have a verdict form. I suspect you all would like to eat lunch and prepare for 1 o'clock closing arguments. Is there anything else from either side before we break for lunch?
Your Honor, I'd like to address, now that the state and the defense have rested, but we've obviously not proceeded to penalty trial, Ms. Rogers and Detective Crumbach would like to come into the courtroom for the end of this trial. Obviously, they would have to remain outside when we get to penalty phase, and those witnesses are testifying. But I would.
They want to watch the closings.
They want to watch the closings, and they want to be in the courtroom when the verdict is read.
Your Honor, I would prefer the sequestration continue to apply throughout. We would not want any sort of state closing arguments or defense arguments to influence any sort of testimony that may occur when the state's attempting to prove aggravation.
Without pulling it up, Mr. Diaz, I mean, they are not within the specified.
They're not next of kin. They're clearly not next of kin.
Right. So, in an abundance of caution, if there was no objection, I would allow it, but with an objection, I'm not going to allow it. There is an objection, correct?
Yes, sir.
All right, I'm not going to allow it. How many copies we're going to print? We'll print those now so that you all can take a look at them, make sure that they're as we discussed. But how many copies does the state want?
I just want 1.
And defense?
Yes, please.
3, please.
Okay, so 1 for me, 3 for defense, 1 for state. We'll get 5 copies. If you want to remain in the courtroom, it'll take us a little while, but we'll get you those, and we'll come back at 1 o'clock. Was there anything else from the state?
No.
Anything else, or anything from the defense?
No, Your Honor, I'm just double checking 3.7 real quick just because there was an issue with the other one.
Sure.
It's just formatted a little bit different, so I'm just making sure that there's no issues.
If you need to come up and look at my staff attorney's computer screen before we print, the last thing I want to do is print them and then find out that there's.
Right.
Pull up 3.7. No. Our, whatever our current version of 3.7 is. I have it in front of me, so if you have any questions as to the one that's going to be printed, or if you'd like to come up and look at it, you're welcome.
Judge, can I just clarify? Is the defense objecting to the people being in the room when the verdict is read? There's no argument or anything then.
Is the objection include, as previously discussed, it may have included the closing arguments and the reading of the verdict. Is there any objection to them being present for the reading of the verdict?
If we could revisit that, please.
I'm sorry?
If we could revisit that later, I'd appreciate it.
Yeah. The jury's going to be deliberating. I want to go back and look at the rule, and certainly if you have any case law So they're reserved. They're not saying that they have objection to that. I want to do research on it. If you want to present case law on it, it is something that we will have plenty of time to decide.
I understand. I would just ask to address it.
While the jury's deliberating, once I send them out.
Yes, sir.
Because they won't have a verdict till after they deliberate. So it's
Yes.
something that we can discuss while they're deliberating.
I understand.
3.7 is fine. The only difference is just that it says whenever the phrase reasonable doubt, and the standard says whenever the words reasonable doubt.
What do you want? You get to pick.
That's fine.
Your pleasure.
No, that's fine. I
Which is
just
fine.
wanted to, a phrase is fine, I just wanted to make sure it's just formatted different so it looks shorter, but it's got all of the other language from it, so that's fine. I have no objection to it.
No objection? Okay. All right. We will print it. We'll provide it to you. Is there anything else from the defense?
No, Your Honor.
All right. It is 12 o'clock. That gives you 1 hour, which should be sufficient time to have a nice lunch, prepare, and we will come back at 1 o'clock for closing arguments. Thank you all. Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good afternoon. Welcome back. I hope everyone had a nice lunch. I think I know where some of you ate lunch. I promise you I did not follow you there. That's a regular place where I go to grab lunch at Publix. So, thank you all for being back. I do have to ask you first, was anybody exposed to anything about this case outside of the courtroom between the time that we broke for lunch and the time that you've returned by show of hands? Let the record reflect there are no hands. Did anybody discuss the case either amongst yourselves or with anyone else during the break? Again, no hands. Let the record reflect. Thank you all again very much. As you may recall from the opening instructions, after the attorneys have rested their cases, they have the opportunity to present closing arguments. I have one very brief instruction that I intend to read you before their closing arguments. Then after their closing arguments are completed, I have the more substantive instructions regarding the law that applies to the case. I also want to let you know that this copy of the instructions will go back into the jury room with you, and you will have it in the jury room. So I'm going to give you the first instruction before they give their closing arguments. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Diaz, is the state ready to proceed?
Yes, Your Honor, thank you.
You may.
In the not too distant future, the group of you will retire to the jury room and you will have a chance to start your deliberations. I want to use this opportunity to talk to you about some of the things that you're going to be read by His Honor. He held up the packet of instructions that he's going to give you. We've had a chance to see those in advance, and so I'm going to talk with you about them. But obviously, the words that actually come out of the judge's mouth and the packet he actually gives you, that's the law. So this is the verdict form, and this is the way by which you ultimately tell us what your decision is. And so you may have come into this trial, although I think I addressed it on jury selection, if you remember back 2 weeks ago, thinking that it was either guilty or not guilty, and that's not exactly correct. So on the verdict form, you're going to see 4 choices. There's first-degree murder, that's choice number A. You're going to see second-degree murder, that's choice number B. You're going to see manslaughter, that's choice C, and then you'll see not guilty as choice D. These are arranged in a particular order for a reason. The highest level of offense is listed at the top, first-degree murder, then second, then manslaughter, and then obviously not guilty. As we discussed during jury selection, you may remember my cheeseburger analogy or my hamburger analogy, and this is where that all comes into play, okay? Manslaughter is the hamburger. Second-degree murder is cheeseburger. It's everything that hamburger is, but it's got a little bit extra. And then bacon double cheeseburger is first-degree murder. It's everything cheeseburger is, but it's got something extra. And so as you go back, you will be asked to decide which of these 4 options is the correct answer. And I submit to you that having heard all of the evidence, including the testimony and the exhibits that you will have a chance to take back and look at for yourself, including the videos that you can watch again, you will apply the law and you will see that the only just verdict is first-degree murder. Now, if you're looking carefully at this, you may see that there's also this other part about something here you have to check. During the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use, or he did not carry, display, so on and so forth. And we're going to talk about that too, because that's something that you haven't heard about. You'll get an instruction that applies for that as well. But it's very simple. You will go back, and when you reach your verdict, you will check either A, B, C, or D, as it says. And if there's one of these things that's an or, you're going to check either one or the other. That's it. That's how you ultimately tell us your verdict. So I want to talk with you about some of the rules that you'll get in a variety of places to help you understand the job that you're supposed to do before we even get to the question of, did the state meet its burden, which I submit to you we did. You will get an instruction, which will actually be one of the last instructions the judge reads you, and it's called submitting the case to the jury. It's 3.13. You don't have to write it down because, again, you'll get it. But the first thing is, there are no other laws that apply to this case. The judge has had the chance to review the facts and to address the law, and the packet has been created, and whatever laws apply, that's what's been given to you. So if at any point you find yourself back there thinking, well, like, is there some other law that plays in here? What about this thing that I think might be the law? Remember, we talked about this. Your job is to apply the law as it is, not as you think it should be, or it could be, or it would be. The judge is giving you all of the instructions. The next one is the verdict form. Let me zoom that out just a little bit. Okay? The state of Florida carries the burden. The government carries the burden. All right? The burden is beyond and to the exclusion of all reasonable doubt. But there's a trade-off for that. If the state of Florida proves to you that the defendant is guilty, you should, not could, not might, not may, you should return a guilty verdict if we have convinced you for the highest offense that has been proven beyond a reasonable doubt. And I return to what I talked about in jury selection. When the state of Florida has convinced you of first-degree murder, I have inherently convinced you of second-degree murder and manslaughter. That's the only way that can work. So I would certainly convince you of the lessers, but you find him guilty of the highest, which again is ranked very easily on the verdict form. It starts at the top. We prove first-degree murder. You find him guilty of first-degree murder. You will receive rules for deliberations, and I'll talk about some of these other ones, but I want to talk about this one first, number 5. Whatever verdict you render must be unanimous, which means that each juror must agree to the same verdict. That means that when the time comes to check the box on the verdict form, you have to all agree to check that spot, okay? But why you check it doesn't necessarily have to be unanimous. There is a question that you will ultimately have to answer for yourself. Did the state of Florida prove premeditation? And where and when did premeditation start? And that may be slightly different for all of you, and I will talk about that in a moment. But one of you may think it starts a little bit earlier or a little bit later. The only question is ultimately, do you think the state of Florida has convinced you the defendant had sufficient time to reflect before he committed the crime? And whether you think he had 3 seconds, 30 seconds, or 3 minutes, the state has convinced you. So you only have to be convinced, and you have to agree on the final decision, but you may have slight disagreements. You know, you may think there's 7 wounds, there's 8 wounds. You may think that there's this wound is defensive and that wound isn't defensive. You can have these disagreements. The question is, when it comes time to check the box, are you unanimous? And if you're convinced and everybody else is convinced, you are a unanimous under the law. The next is this one, and we talked about this. Whether the state has met the burden of proof does not depend upon the number of witnesses it has called, nor upon the number of exhibits it has offered. Now, I think in total you've heard about 31 people in this trial, and there's somewhere in the neighborhood of almost 70 pieces of evidence, not counting each individual photo that is, then clustered inside. But that's not the issue. The issue is the nature and the quality of the evidence presented. That is the issue. And I submit to you that on the nature and quality of the evidence that has been presented, the state of Florida has proven that this case did occur, that the defendant is the one who caused the death, and that he did so with a premeditated intent. The state of Florida has met its burden. And so you may say to yourself, well, there's no eyewitness. And that's true. There's no living person standing there to say what they saw. But there is no requirement that there must be an eyewitness. You may say there is no video of the event. There is no audio recording of the event. And those things are true. There is no getting around that. But that is not the requirement. As I discussed with you, there is no formula for guilty. The state of Florida must convince you, and I submit to you the state of Florida has convinced you. It's a question of the nature and the quality, not the number. So I want to draw your attention first to 7.1, which is the introduction to homicide. And again, you're going to see some basic things that we've already talked about. The defendant's accused of first-degree murder. It includes the lesser crimes of second-degree murder and manslaughter. They're all unlawful. If you find that Kay Baker was killed by Matthew Terry, you then consider the circumstances to decide whether it's first, second, or manslaughter. And again, these are all things that we've covered, but we're going to come back to this instruction in a moment. So let's talk about what is murder in the state of Florida. First-degree murder has 3 elements. Very much like I suggested, there is, top bun, the middle piece of meat, bottom bun, sort of like hamburger, although obviously this has got more bells and whistles than manslaughter. There's 3 elements. The first one is Kay Baker is dead. You know that to be true. The state of Florida entered a stipulation that is in evidence. You will be able to take that back. The state of Florida and the defense have agreed that Kay Baker is dead. That element is met. There is no doubt there. Then there are 2 more elements. The death was caused by the criminal act of Matthew Terry. That's the question of identity. And there was a premeditated killing of Kay Baker. That was the intent element. And what you will see is the difference between all of the offenses is the question of intent. The intent gets a higher level as you move up. But I want to stress this, because we talked about this. Killing with premeditation is killing after consciously deciding to do so. The decision must be present at the time of the killing, meaning you have to have decided beforehand. You can't decide afterwards. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period must be long enough to allow reflection. And I submit to you that in this case, premeditation starts well before the killing does. It starts before the first knife wound to Kay Baker. But premeditation lingers and continues on through every step of this murder. Every time the defendant makes the choice to again plunge the knife into the body of a woman, to slice her open, to cut her throat, to cause her to bleed to death, every single one of those is an intentional act where the defendant is again making a choice. I stabbed her once, it wasn't enough, let me stab her again. That still didn't get her, let me stab her again. Kay Baker suffers multiple wounds on the way to the one that ultimately claimed her life. And each of those is an act of premeditation. But again, I submit to you that premeditation starts long before that. And we will talk about that in a moment. So, as part of the instructions, as I told you, you will also get an instruction about the use of a weapon. That thing where you have to check the either or option about did carry, use, threaten to use. That's this instruction. And you'll see this instruction repeated for each of the offenses, which is why on the verdict form, each of the offenses has that option to choose beneath it. This is just one I'm using for example. It's the one for first-degree murder. You'll see that the state of Florida has to prove to you the defendant did carry, display, use, threaten to use, or attempt to use a weapon. And if we did, you should find him guilty of first-degree murder with a weapon. So you check A for first-degree murder, and then you check did carry, use, threaten to use, display, or attempt to use. And that shows that it's with a weapon. That's what this instruction is about. You'll see that a weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design. I submit to you the weapon here is a knife. And you might think that a knife is typically used for in a kitchen to chop vegetables or maybe to chop up some chicken or whatever the case may be. But it's also any object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. So even if the knife in this case is a knife that would normally sit in a kitchen waiting for some chef to come along and use it for its normal purposes, the minute it's picked up and used as a weapon to inflict murder, it's a weapon. It's a weapon at least under the second option there. So I want to talk with you about a variety of things that you're going to see in the instructions, ways by which murder may not be murder, meaning a killing may not be unlawful. One of the ones you'll see is here. This is again in the introduction to homicide. You'll see the discussion of justifiable homicide. A killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant. That is a form of self-defense, right? Someone is trying to kill a person, that person can defend themselves. Matthew Terry was not resisting anyone's attempt to murder or commit a felony upon him when he killed Kay Baker, because Kay Baker was not committing a felony or trying to kill him. There's also the intent to commit a felony in any dwelling house in which the defendant was at the time of the killing. And I submit to you that yes, this case certainly started in a home, a dwelling house, but that's not where it ended. And so that section does not apply. There is nothing under the law that is given to you that says that this killing is justifiable. It's not self-defense, and so it cannot be excused for some justification. You'll also see this instruction for excusable homicide. All right? And what you're going to see over and over are the words accident and misfortune. The killing of a human being is excusable under any one of the following three circumstances. Whether the killing is committed by accident and misfortune, which is not what happened here, in doing any unlawful act by lawful means with the usual ordinary caution and without any unlawful intent. So you don't even have to struggle with the usual ordinary caution and without any unlawful intent, because what happened to Kay Baker is not an accident. It is not a misfortune. It is an intentional killing. Whether the killing occurs by accident or misfortune in the heat of passion, upon any sudden and sufficient provocation. And we're going to get to heat of passion again in a second. But again, it's not by accident, it's not by misfortune, it's not excusable. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Well, first off, there is a dangerous weapon used. That's clear. The knife killed Kay Baker. That's a dangerous weapon. But even still, again, accident and misfortune immediately disqualifies this from excusable homicide. And so it's not justifiable. It's not excusable. You may look to the actual instruction for murder again right? We saw the top part, and as you move towards the bottom, you'll see here, an issue in this case is whether Matthew Terry did not act with premeditated design to kill because he acted in the heat of passion based upon adequate provocation. In order to find the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, and I wanted to point out to you that A, B, C, and D all end in the words "and," because it's got to be all of them. It's got to be all of those things to be excusable under the heat of passion theory. Okay? So there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused the death, and Matthew Terry was in fact so provoked and did not cool off before he committed the act that caused the death of Kay Baker. And I submit to you that does not apply. Whatever argument took place between Matthew Terry and Kay Baker on that night, what Matthew Terry did to Kay Baker was not what a reasonable person does. It is not how a reasonable person reacts. This is not a situation where a man comes home and finds his wife in bed with another man and his whole world disintegrates in a moment. Maybe that would apply then. But that's not what happened here. What you have is an argument that started at 10 o'clock and carried all the way until 12:30, slowly escalating. Multiple chances for the defendant to cool off. Multiple chances for a reasonable person to cool off. Nothing about what happened here is the actions of a reasonable person, and I submit to you that the heat of the moment, based on adequate provocation, does not apply. As we discussed before, you'll hear this. You probably, I think, heard me read these words directly. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. That does not say it is not a defense to first-degree murder, where it could be a defense to second or manslaughter. It's not a defense to any crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that he lacked the specific intent to commit any crime. Matthew Terry was intoxicated that evening. You can watch the video. You'll see him drinking. You've heard the testimony of the people who were there, who will tell you that he had clearly been drinking and he was clearly under the effects of alcohol. And you will see the medical records, which will tell you that after he stopped drinking somewhere at 11:30 and is found somewhere about 5 o'clock in the morning, almost 6 hours later, he's still a .072 because he's had 5 hours to sober up. Voluntary intoxication is not a defense. So I submit to you the question is, did the defendant commit this murder, and did he have the requisite intent? I return back to the instructions on murder. And I submit to you that he did. Was the defendant the one who caused the death of Kay Baker? He's the last person with her at the landing. He's the person with her in the car. He's the person with her that gets home. You can see their shoes kicked at the front door. You can see Miss Baker's phone sitting on the kitchen counter. You can see the defendant's phone and the keys to his car sitting on the nightstand in the bedroom. You can see the shorts he was literally wearing when he was at the landing that he's not wearing when he gets arrested, and they're sitting right by the door where he kicked it off. And if you look carefully and go look at the photos, you'll actually even see that Kay Baker got home and changed shirts. In the video, she's wearing a red t-shirt. When she's found, she's got a sort of purple camisole on. And if you don't think she got home, I will submit to you that go look at the photos from inside the house, and the thing that you'll see that hasn't really been discussed is the same thing that every woman knows. After you've been at work all day, after you've been out partying, first thing you get home, the first thing you want to do is you take your bra off, go look at the picture, and you'll see her bra tossed right on top of the hamper when she got home. Kay Baker and Matthew Terry got home. They're alone. There's no forced entry into this home. They are the last two people together 30 minutes before Kay Baker is dead. And the defense may suggest to you that somebody broke into this home and point to the window that is the screen pushed out. But that's why I took the pain to show you that the stuffed animal sitting on the floor comes from inside the bedroom. It's not out of the house because somebody is climbing out of the window. The stuffed animals that are by the window are not pushed into the room. They're still sitting on the bed where they belong in a kid's bedroom. They're pushed out because somebody went out the window. So Kay Baker and Matthew Terry are alone in a house with no sign of forced entry. There's clearly some argument that happens in the house that leads to not only the master bedroom door, but the kids' bathroom door both being damaged. I submit to you, Kay Baker is the person who goes out that window. She's a small framed female. She runs into her kid's bedroom, she locks her door, she opens a window, and she crawls out a window. Because she's trying to get away from the person that's attacking her, the only person that's in that house, that man. And that's why the front door is open. Because the defendant comes out the front door and chases her down. That's why Kay Baker isn't killed in the bedroom. That's why she isn't killed right outside the window. The defendant is taking the time to run around the house to try to intercept her. That's who did this. He's the last person seen with her, and when the time comes and he's found, he's literally caught red-handed. Red-handed because he's got Kay Baker's blood on his hands. The same hand that ran from Kay Baker, ran along the fence line, got to the edge of the fence, and first started to think about climbing into the bushes, and put his hand on the fence to brace himself. That's Matthew Terry and Kay Baker. That's his hand on the fence. And you might say, well, if he's right there and he's going to climb through the bushes, why doesn't he do it? Because if you look at the path, what happens next is Jonathan Figgins comes outside. He hears a voice, and not long afterwards, the lights are turned on in the backyard of Jonathan Figgins' home, and the defendant is standing at the edge of the fence line. So now he runs away from Jonathan Figgins, he runs away from the light in the backyard of the Figgins home, and he runs diagonal across 6209 to 6207, and then he crosses the bushes. The defendant is the person who committed this crime. He is the one who caused the death of Kay Baker. And so, did he do it with a premeditated intent? I submit to you, yes. Now, I need to be clear. What you will not see in the instructions is the word motive. Why he did it is different than did he think about it. And we have presented to you the motive. Matthew Terry was upset at his girlfriend for what he thought was an act of infidelity, dancing with another man. He was so upset about it, he had to argue about it with her friend, then with her and her friend, and then he had to make another phone call on the way home because an hour and a half later he still hadn't let it go. Now, was he intending to kill Kay Baker at that moment? That seems unlikely. But they get home, and now the couple's having an argument. And again, maybe she tells him, I don't love you, I've had enough of you, this is over, get out. Or maybe she just tells him, you know what, you're being an idiot, sleep on the couch. But something upsets Matthew Terry. Something upsets him enough that he realizes he is no longer in control. He cannot control Kay Baker. Because watch that video when Kay Baker goes to the bathroom. You will watch him watch her. And he immediately goes in right after her. And when she comes out and she's dancing with her friend, and he thinks she's dancing with another man, he walks past them, and the first thing he does is he turns and looks back at them. But keep watching the video. Watch Matthew Terry go outside onto the patio and watch him get back up from the table, walk all the way to the door inside the bar, and he peeks in because he's checking on Kay Baker. Because he thinks that he needs to supervise her. He needs to control her. And I submit to you that whatever happened in that home, whether it was an argument about dancing, or it was the threat of the relationship ending, or he just felt disrespected because she told him to sleep on the couch, that's where it started. That's where doors start getting closed. That's where the master bedroom door gets closed. That's where the master bedroom door gets broken. And Kay Baker gets out of that master bedroom and finds her way to the kids' bathroom and to the other bedroom, and she pulls doors closed, and the defendant comes kicking in doors, and Kay Baker is frantically scrambling out of a window. And so the defendant chases after her. And that is where intent starts. Because let's be really clear, some weapon killed Kay Baker, and I submit to you it's the paring knife that comes from the butcher block sitting on the counter where it's the only knife in the house unaccounted for. And if you agree that that's the knife that killed Kay Baker, then someone had to bring it outside the home. And that's the man who brought it. When he grabs a knife, when he chases a woman down who's fleeing, when he's been chasing her in the home, when he's kicking in the doors, the premeditation is already forming. And every step that he gets closer to her as he chases her down, the premeditation is only growing. Kay Baker suffered a wound to the back of her neck. A wound that Anna Cox told you had to be higher than the shirt that she's dripping down onto. Jonathan Figgins told you he heard a thud, like somebody hitting the ground. And Anna Cox told you that Kay Baker's throat is open right next to Jonathan Figgins' wall, and very shortly thereafter, and very briefly, she's moved to the place where she died. The place that she never moved from again. Kay Baker got slashed in the back of the neck because someone was chasing her from behind. She was running. She gets hit in the back of the neck, and in the struggle, she gets knocked to the ground. And someone is on top of her. She is either laying on her back, or she is basically laying face down on the ground, and somebody is going to open her artery, and it's going to spray on that wall that you saw. That is intent. And it's that man's intent. It was that man's intent to kill Kay Baker that night. It was his intent with every single time he stabbed her, he slashed her, he cut her. That is the only reasonable conclusion. Was Matthew Terry angry? Yeah, I'm sure he was. Does that mean he didn't commit first-degree murder? No. He was not acting in the heat of passion as a reasonable person. He was acting as a boyfriend who wanted to put a woman under his thumb, who wanted to show her that he was in charge. That's who Matthew Terry was. In a moment, I will sit down. Before I do, I just want to talk with you about this. Whenever the phrase a reasonable doubt is used, you must consider the following. And I'm only going to read a portion of it. That's not because I'm trying to hide the rest of it. You're going to be given this in black and white. You can read it for yourself. But a reasonable doubt is not a mere possible, speculative, imaginary, or forced doubt. It is easy. It is too easy to fall into what is possible, to speculate about what might have been, to imagine about what the real story could have been, to force yourself to believe something that defies common sense. That is not reasonable doubt. There was no other person that attacked Kay Baker that night. The defendant did not rush to her aid and get his blood on his hands because he was trying to help his girlfriend. He did not either get chased by the phantom attacker nor chase down the phantom attacker as if it's some narrative that he's the brave hero. Matthew Terry killed Kay Baker. He ran from the scene. He ran through bushes. He ran a football field down the road. And what he did was he opened his own neck. He opened his own neck. And then he laid in the darkness and in the bushes for 5 hours until he was found. Do not fall into the rabbit hole of what is possible, imaginary, speculative, or what you have to force yourself to believe. Use your common sense. Look at what is reasonable from the facts. And when you do, it is clear the state of Florida has shown you what has happened. And if you find yourself thinking, I just wish there was someone who had seen what happened that night who could tell me for real, it's Kay Baker. Kay Baker can't say it because Kay Baker is dead, and she's dead because that man killed her. Find the defendant guilty as charged. Thank you.
Mr. Perry?
Matthew Terry didn't kill Kay Baker. And there is not one piece of evidence that they have presented with their 31 witnesses and their 70 exhibits that changes that. He didn't do this. And they haven't proven that he did. Remember, I don't have to prove anything. They have to prove this case beyond and to the exclusion of every reasonable doubt. And I'm going to show you why they haven't. Even if I tell you nothing, you would still have to examine whether they've met that extraordinarily high burden. Remember, we talked about the line, where you, as the jurors, get to determine where the line for beyond a reasonable doubt is. And if you get here and you say, look, this is my line for beyond a reasonable doubt, and if they're even slightly back from it, you must vote not guilty. I submit to you, they're way further back than that. We're not even close. But remember that visual. Slightly back from that line. Right here. You must vote not guilty. The state said a lot during their closing. They said Matthew Terry wanted to control Kay Baker. They said he wanted to have her under their thumb. Where's the evidence of that? Where's the evidence of anything they claim happened that night? There isn't any. There is zero evidence of what occurred past 11:56 p.m., past that last text of "It's all good now." As of 11:56 p.m., the evidence shows that there was nothing going on, nothing wrong. Now, we're going to go through every single one of those witnesses, 31, and by the time we're done, you're going to see why there is no evidence, and certainly none that can get you to the line of proof beyond and to the exclusion of every reasonable doubt. I want to start first, though, by talking about the instruction that the state put up in regard to what they have to prove here, because they're claiming that this is first-degree murder. Even if you accepted their version as true, which for 1 second I will ask you to do just to look at this. He's not guilty of first-degree murder. There has been no evidence presented about any reflection. So even if you accept their version, he cannot be guilty of first-degree murder. The law requires the period of time for premeditation to allow for reflection. What evidence has been presented that there was any reflection whatsoever? They told you this wasn't justifiable homicide. This wasn't heat of passion. He didn't walk in on her with another man. How do we know that? We know nothing because they haven't given you any evidence of what actually happened in the 30 minutes after that all good now text. So this cannot be first-degree murder, even if you believe their theory. And that is all that this is. It is a theory that they've presented to you. No evidence, just a theory. So let's talk about, though, the 31 witnesses. The first one I want to dispense with, and really it ties in the second one too. Michelle Rogers and Detective Crumbach. Detective Crumbach just came in to show you the photographs of the two knives, really one knife. But remember, there were actually two there. There was a knife that was outside and two knives that were missing from the butcher block. What happened with that other knife? For perhaps Matthew Terry was defending himself then. There was another knife missing. But we don't even need to get into the weeds to discuss Michelle Rogers and how inconsequential her testimony was. Why did they put on Michelle Rogers? What does that have to do with Kay Baker? Absolutely nothing. They put her on to manipulate you into thinking they had evidence because they don't. Michelle Rogers' incident has nothing to do with what happened to Kay Baker. Close your eyes for a second. Don't open them until you have the answer for yourself to this question. Go ahead and take a minute to close them. Ask yourself this. When we left at 5:30 last night, if you were asked to vote guilty or not guilty, how would you have voted? When you have the answer to that, open your eyes. If your answer was not guilty then, it should be not guilty now. Because Michelle Rogers' testimony means zero to what happened to Kay Baker. She had nothing to do with this. And they brought her in to try to manipulate you into thinking there was evidence of Kay Baker's murder when there isn't. Let's talk about a few things that did come out during Michelle's testimony, though. Ms. Rogers conveniently remembers everything about what occurred except what started the incident, going back to my comment about 2 knives being missing. Perhaps what she doesn't want to tell you is he was defending himself then. Ms. Rogers tried to claim she wasn't drunk, but when confronted with her prior statements, admitted she was well over the legal limit, about 1.5 times over the legal limit, in fact. She tried to say that she hadn't previously stumbled and fell when she went to Matthew's parents' house in order to pick up their child, who she then drove after being drunk, home. Then she had to admit, well, yeah, I guess I did say previously I stumbled and fell. She tried to say, oh, maybe I corrected that in one of my multiple versions later, but she admitted right after it occurred, she did tell people, yes, I did stumble and fall. She tried to say she was just upset. When she was asked if she was angry, she tried to downplay that and said no, until she was shown a transcript where she actually had previously said she was, quote, pissed off. That's certainly more than upset. She tried to say she didn't ask for more than $250,000 in compensation until she was shown the spreadsheet she herself put together asking for over $250,000. And then she slipped in that she only got 13 to 14. I submit to you that's why she was here. Because the woman who said, quote, she was pissed off is still pissed off. Because she got $13,000 to $14,000 from Matthew Terry when what she wanted was $250,000. Don't let her testimony and their manipulation using her change what you knew at 5:30 last night. And that is that they have no evidence that Matthew Terry did anything to Kay Baker. So really, out of the 31, we have 29. And we're going to go through each one, and you'll see why there is still, even with 29 witnesses and 70 exhibits, zero evidence that Matthew Terry harmed Kay Baker. Remember, this is the woman he lived with, the woman he loved, the woman he moved here to be with. The woman Kelly and Sean Andrews told you he went out with them every other weekend. The woman they had no thought there was going to come any harm to when they left together. This was someone he loved. And nothing they have presented changes that fact. The first witness I want to talk about is Dr. Perkins. She was the medical examiner. She did the autopsy of Kay Baker. She said that the blood doesn't tell us anything except that Kay Baker was there. Of course, we know that. That is where Kay Baker was killed. No one's disputing that. No one's saying she was moved or the body was manipulated in any way. She said that she doesn't know if all the blood was Kay's or if there were 2 victims. Well, we know there were 2 victims because the DNA shows Matthew Terry was injured, and in fact, his blood was found on the scene. She indicated that she doesn't know if all the blood was one or two victims or if a third or fourth person was involved. Remember that. No indications that prevent a third or fourth person being involved. She also testified that nothing that she had to say tells us anything about who committed the murder. And the reality is that's the question here. Who did this? Not whose blood there is. We know whose blood there is. It's Kay Baker's blood and Matthew Terry's blood because they were both attacked. The question is who killed Kay Baker? Dr. Perkins told us that there was nothing about her testimony or about the injuries that could tell us the sequencing of events, so we don't know exactly how any of the wounds actually occurred. She testified that the wounds could have been inflicted in seconds. That's important because of Jonathan Spiggin's testimony, which we'll get to in just a moment. But remember that. All of those wounds could have been inflicted in seconds. And she told you that she can't tell you if Matthew Terry's wounds were inflicted by another. She doesn't know. They want to imply that they may be self-inflicted. But remember, Dr. Perkins, Dr. Devers, nobody could say that those wounds were self-inflicted. Why? Because they weren't. Remember, they have the burden. If something's unanswered, you can't give them the benefit of the doubt and go, well, maybe they're right. They have to prove it beyond and to the exclusion of every reasonable doubt. The next witness was Dr. Devers, and I mentioned her as I was talking about Dr. Perkins' testimony. Same thing. Dr. Devers indicated that she can't say either whether Matthew Terry's wounds were self-inflicted or inflicted by another. Again, that means it is just as plausible that they were inflicted by a third or fourth person. You cannot give the state the benefit of the doubt when they haven't presented you the evidence. The next is Dr. Mendoza. Dr. Mendoza is the ER doctor who actually treated Matthew Terry. She told you that she too, even though she treated him, saw him in person, she can't give any opinion as to whether those wounds were self-inflicted or inflicted by another. She told you that there were notations in the records about self-infliction, but that could have just been something that needed to be ruled out, not an opinion. She was quite clear. She had no opinion in that regard. She said that sometimes there was confusion when Matthew was brought in, and that doctors sometimes are actually assigned to one patient because someone improperly clicked on it, assigned to the wrong patient. Nurses have this happen, and those things get put in those medical records. They're not accurate. She also indicated, in fact, that sometimes the information that ends up in those records are things that come from EMS or the police officers, and that those things are not right. The notation about Matthew Terry saying he did this to himself is wrong. That came from the police officers, just like Dr. Mendoza said occurs. How do we know that? We'll get to that when we talk about how he was found and what the police did when they found Matthew Terry. But remember Dr. Mendoza's words about how EMS and police officers give information that sometimes ends up in the medical records and turns out to be inaccurate. She also indicated that Matthew Terry's wounds were such that they went through skin, fat, fascia, a layer of sinew, platysema, which is a layer of muscle, and then into the sternocleidomastoid muscle. This was not some little nick. This wasn't just, oh, he's going to pretend to be injured. Remember all of the layers that had to go through for Matthew Terry to end up needing surgery for his wounds. He had surgery. These were serious, very significant wounds, as you can tell from all the blood you saw all over him in the photographs. The next witness was crime scene tech Janicek. Crime scene tech Janicek took photos and collected swabs. The pertinence of that, not just so that you can have the photographs to look at, but really is to look at the damage. Now, the state wants to tell you, oh, there's damage to a bathroom door and there's damage to a bedroom door, and that must mean that there was a fight inside the house. No, it doesn't. You heard no testimony about a fight inside that house. How do we know that that damage wasn't there for months? How do we know that that isn't damage left by a landlord who just doesn't really care about keeping up the property? They've presented no evidence. Now, one thing to posit, though, is that third door, the door that was locked, the door that goes into the bedroom that had the window screen out. That wasn't kicked in. Think about that for a moment. Their version is that Matthew Terry kicked in a bathroom door, kicked in a bedroom door, but then stopped, didn't kick in the door where Kay Baker was barricaded? Does that make any sense? If he kicked in the bathroom door, kicked in another bedroom door, and she barricades herself in that bedroom, isn't he kicking in that door too? Wouldn't that make more sense? That's not what happened. That damage to the bathroom door and to the other bedroom door is old, and there's no proof to the contrary. None. You cannot give them the benefit of the doubt. They have the burden. Remember, there's no disarray in the photographs of that house. There's nothing knocked over. There's no blood other than the blood that the new officer accidentally transferred. There's no incident that occurred inside that home. No evidence whatsoever that there was any incident in that home. Now, they, of course, will want to say, oh, look at the hanger. Are you kidding? There's a hanger that's bent, so we are supposed to assume more assumptions they're asking you to make. We're supposed to assume that somebody who kicked in a bathroom door and kicked in another bedroom door stopped and said, oh, maybe I'll just try to use this hanger to get into where she's barricaded and give her lots of time to get out the window. That makes no sense. There was a bent hanger. Who cares? That doesn't indicate anything about what occurred. And certainly, there's been no proof that that hanger was used for anything at all. The next witness was Detective Watson. He took a swab of Matthew Terry. Doesn't really tell you anything. The DNA will, of course, talk about when we get to those witnesses. Deputy Bateman, he's the person who took the aviation video that you may recall. It's the video that had the blur of light. That was where, how they were able to get to Matthew Terry. Well, he told you that he got a GPS location to immediately go there. So there's no indication that there was ever any ability to look for other suspects. It wouldn't have mattered by then. It's 5 hours later. Remember the testimony earlier? It took the police an hour to put up a perimeter. 15 minutes to even respond. Whoever did this was long gone by then. But even if they hadn't been, even if it had been a quicker response, aviation, he went directly there. No opportunity to look for other hotspots, other people. Next witness was crime scene tech Douglas. He indicated that, well, they didn't bother to use the Faro system in order to create a crime scene diagram. Their drone photos didn't save for whatever reason. They didn't bother to process the window screen, the screen that the state is relying on to tell you that, oh, Kay Baker must have gone out that must have been her pathway. That's how she tried to escape. They didn't bother to look for prints or DNA there. They didn't even bother looking for footprints. Kay Baker is barefoot. Matthew Terry is barefoot. Did they try to look for footprints? He tells you they didn't even do that. He did indicate, though, that he took a swab from every marker, and not every marker, as we know from later testimony from Detective Redo, was tested. 50 items. They tested 10. They tried to say, oh, we have a procedure. We can only submit 5 at a time. That's ridiculous. He told you all they have to do is ask to submit more. They have to have a reason, he said. Yeah, like a murder trial coming up. They didn't bother. Just like they didn't bother with the Faro, just like they didn't bother with the drone or having the drone photos in a manner that would reasonably save, just like they didn't bother to test the screen for fingerprints or DNA, just like they didn't bother to look for footprints. They didn't bother. Why? Because they assumed it was Matthew Terry, which is obvious when we get to the officers who actually located him and what they did. But first, let's talk about the two first responding officers, Deputy Ellis and Deputy Strahan. People are new. They make mistakes. But Deputy Ellis actually transfers blood from Kay into the home, and Deputy Strayhand was brand new in his job supervising her. So the first two people who get there are brand new in their positions, and some mistakes were made. In addition, though, I would just point out, there's really nothing to their testimony that changes the fact that the state has presented zero about who committed this crime. The only thing that they testified to was finding Kay Baker's body. Again, we don't dispute that Kay Baker was there. We signed a stipulation. That is her. We're not saying the body was moved or manipulated in any way. And then they end up going into the residence. But again, no signs of any struggle in that residence. No blood, nothing. The next witness is the neighbor, Douglas Hicks. Well, he tried to say during his testimony that he heard crying or yelling out, but then he admitted that when he originally had reported all of this, he actually had his TV on, and he had previously said it was only gasping and gurgling that he heard. And remember, Ruth Figgins said he was actually drunk that night. So his explanation of crying or yelling really isn't reasonable. What he said that night is it was gurgling or gasping, which we don't dispute. I'm sure Kay Baker, from her very serious injuries, was gurgling and gasping. That doesn't tell you anything about who did this. Jonathan Figgins, he's the one who tried to help her, the husband of the 911 caller, Ruth Figgins. The state said during their opening, well, Jonathan Figgins put on his lights, and that's what made Matthew go in the other direction. How would that have occurred in those seconds? Think about that. If Matthew suddenly gets there, lights go on, why would he go back into the yard? And if he did, just to immediately go to the area where they claim he went to try to get around? How would all of this have happened? Remember the testimony in regard to all of the pink. All of the pink spots on this chart that was their expert's chart are the unknown things, the things that aren't tested. They want you to believe that he gets to you, lights go on, and he goes, I better not go that way, there's lights. So he decides to run back down to O, then run across this way, and then hang out up here a little bit, because remember, there was testimony about the concentration of blood being bigger in this area where there's D, G, E, F, H, A, B, C, and then cross over and go that way. Why? How? What on earth would that make any sense? Think about it. If their version is true, if Matthew Terry gets to you and suddenly lights go on, what would make more sense for him to do? Get down in that brush. Go directly that way to Lithia Pinecrest and get the heck out of there. Their version, yet again, doesn't make sense. By their own evidence, by what their own expert said, doesn't make sense. But what Jonathan Figgins did tell us, and what makes much more sense, is that it took him up to 3 minutes to get outside after hearing that first thud, because he checked on his daughter, he had to make sure it wasn't her, he thought she had fallen out of bed, that it's very dark behind his house and it backs up to Lithia Pinecrest. He indicated that he heard a noise once he got out there. 3 minutes later, he heard a noise in the woods that could have actually been 2 or 3 people. And that Lithia Pinecrest is a very busy road, and you can walk to Lithia Pinecrest in just seconds. Why does that matter? Put this back up just for you to see for a second. DD, S, R, those are the areas right around where Kay Baker was found. If he heard a thud at that time frame when Kay Baker gets hurt, and it takes him about 3 minutes to get up there, it's not going to be just the seconds that the state's theory says Matthew Terry would have gone to you, and then somehow, for whatever reason, they claim go this way. That makes no sense. What makes more sense is in those 3 minutes, all of this back here is happening. You'll understand that when I get through their witnesses and why their witnesses don't point to Matthew Terry, and I tell you what actually happened. But remember this, 3 minutes is how long this could have taken, not the seconds the state claims, where Matthew Terry just got to you and said, "Ooh, lights are on, I'd better get out of there." Didn't happen that quick. Jonathan Figgins told us that. It took him up to 3 minutes to get out there. A long time for a whole lot to happen. Now, Ruth Figgins, his wife, she's the one who actually called 911, she indicated that she heard nothing before her husband alerted her to what was going on. She said, as you can actually hear on the 911 call, that it took 15 minutes for that first officer to arrive. Plenty of time for the person who actually murdered Kay Baker to get out of there. She indicated that Kay Baker's feet were dirty. You actually could see that in the photographs. Why does that matter? It matters because Kay had gotten home calmly with Matthew. Matthew, by the way, was barefoot too when he was found, because they got home, took off their shoes. Nothing was happening between them. Matthew's keys are by the bed. His car's in the driveway. They're going to sleep. He's in his underwear. As the state mentioned, Kay Baker had taken her bra off because they're going to bed. There's no ongoing argument like they want you to also believe. It's contradictory. Their own theory contradicts itself. There's no ongoing argument. Nothing is happening at that point. And of course, Ruth also talked about Lithia Pinecrest, how big of a road it is, the fact that there is a stream that is crossable in just seconds, that opens up to a big cow field, all of which is an egress or an ingress for the person who actually committed this crime. We have Corporal Royal who testified. He just talked about how he got the video from the landing. So in regard to his testimony, it's just to set up the video. But let's talk about the people that are in that video, because that's really what's more important. The first person let's talk about is Tara Johnson. Tara didn't know what was actually going on. She was dealing with her husband, who was drunk and wanted to go home and kept bugging her, telling her, "Let's go, let's go, let's go." Her son was there too, also drunk, wanting to go home. She had been having her Moscow Mule vodka drinks, and she decides to interject in the conversation between Matt, Kay, Sean, and Kelly. Now remember, you heard the testimony, and we'll talk about Sean and Kelly's testimony in just a moment. Sean and Kelly were very close friends of Matt and Kay. They can talk about that kind of thing if there were some tiff, some silliness going on. Tara didn't even know Matt. She only met him that night, but she drunkenly decides to go get involved in this. And she's claiming now, oh, there was some argument. Really. She didn't know him, so certainly can't judge whether he's upset or not in regard to any way that he would normally react or talk or have a conversation. She's a stranger interjecting. Why wouldn't he get annoyed by her? He wasn't mad at Kay. He was mad at Tara jumping into a private conversation she had no business jumping into. How do we know that? Well, because of the other witnesses who testified. But before we get to them, remember what Tara said. She said, in the end, everything was fine. When she left, everything was fine. They talked about getting together again for Memorial Day. She sent Kay a text saying she had a good time, because everything was fine, and it wasn't the big deal that she tried to make it out to be, interjecting herself in a situation she really shouldn't have been in the first place. But as far as the other witnesses, remember what they said. Sean Andrews told you that he and his wife Kelly, they were best friends with Kay. Kelly has known Kay for over a decade. He's seen Kay pretty much every other weekend for a decade. He is also now, because of Kay and Matt dating, seen Matt every other weekend for months. They're all very close. Everybody, of course, at the landing was drinking. Sean testified that there was a discussion. He described it as heated, but said that there was no fight. There was no yelling, and that Matt seemed fine. But most importantly, what did Sean say? Kay, his wife's best friend, his very close friend of over a decade, There is no way he would have let her leave if he thought there was any issue still ongoing. And he didn't, because there wasn't. There was no issue. Kelly testified, and all the sympathy in the world for Kelly. This was her best friend. Unimaginable losing your best friend in a way like this. But because of that pain, she has made what was not an issue, not an argument, as testified to by her own husband, into something bigger in her own head. So she told you, though, despite making it sound like it was an argument, that there was no yelling. Matt didn't get aggressive with Kay. There was no slapping, pushing, nothing of that sort. She said they stayed an hour after it came up, and the dancing issue didn't even come up again. She said Kay called her and, yes, said he brought it up again, but when she, who is close enough to him to actually say, tell him to cut it out or I'm going to kick him in the balls, he said, okay. He didn't yell. He didn't curse. He didn't say stay out of it. He didn't get annoyed with her like he did with Tara, because Kelly and Sean were practically family. Tara was the reason for the annoyance at the landing, not this silly dancing issue. But most importantly, Kelly testified about that text at 11:56. It was all good by then. The text is all good now. So silly. So stupid. And that's exactly what it was. It was a silly, stupid nothing. Because next is Nicholas Calicochi. He tried to say now, and he too was very close with Kay, and in hindsight he thinks, well, maybe it was an argument rather. So he's trying now in his own mind to rationalize what must have happened. But he told you, the night in question, he said there was no fight, no argument. He described it as, quote, wasn't even a tiff. It was over in 2 seconds, the topic was immediately dropped, and that Matt and Kay went back to their table to have fun. And that's really what it was. It was a 2-second nothing that was immediately dropped. That's everybody who was there that night that testified. Not one reasonable indication that there was any real argument, problem, dispute. You saw the video. There's no large gestures of somebody who's getting heated and upset. In fact, you see Matt go over and put his arm around Kay after it. Kay gets him a drink, or he gets her a drink. They're going on back at the table, talking, drinking, hanging out for another hour with their friends. Nothing happened. This was nothing. Let's talk about the DNA. The next witness is Alyssa Troutman. She said Matt's DNA and Kay's DNA was there. Okay. Remember during voir dire, during jury selection, I said to you, sometimes there are experts who might testify and you think, oh, they're an expert, it must be really important. But it's not on an issue that actually matters. Remember, the only question here is who killed Kay Baker. Of course Kay's DNA was there. Of course Matt's DNA was there. He was hurt too. But what she said that was interesting was that she put into StarMix that there would be 2 contributors. She didn't put in that there could be a third. And what did she say? I wrote it down. She said, I don't know what the program would have done. She doesn't know what the program would have done if she put in a third person. We have no idea. And by the way, 40 pieces of evidence that they didn't even bother to submit for testing. 80% of the evidence. They submitted 10 out of 50. 80% not even bothered to be looked at. The next witness, and we're at 21 witnesses right now. Again, not one piece of evidence yet pointing to Matthew Terry. 21 is Anna Cox. She was the expert who did the map that we've shown a couple of times. She indicated that Kay's blood may have gotten on Matt as he tried to help her. Common sense, right? Jonathan Figgins got Kay's blood on him as he was trying to help her. So did Deputy Ellis. Matt did have Kay's blood on his hands. He did touch the wall where you saw the BB because he got attacked and was bleeding too, and he did stumble into the fence as you saw at the U. Because again, Kay's blood was on his hands from him trying to help her, and then when he got attacked and was bleeding, his blood was on his hands too. Anna Cox indicated that she can exclude that if Matt had gotten Kay's blood on him trying to help her, then was attacked and touched the wall at BB, and then stumbled into the fence at U, that his and Kay's mixed DNA could have gotten on the wall and the fence that way. That's their expert. In fact, she actually talked about the directionality of the blood at BB. That's the blood on the wall, going towards the backyard. Where else is that towards? Towards you, towards the fence where he stumbled into. She indicated that there was a large concentration of blood at H. Now, just to be clear, which H, because there are two, the H we were talking about was the one way over here. Try to zoom out to get this all in one. There we go. The H that we're talking about with the large concentration of blood is over here. Why is that important? Remember that location, and I'll tell you why that's important in just a few minutes. But she said there was a large concentration of blood there. Unfortunately, we don't know whose blood, because they didn't bother to submit it, but a large concentration near where Matt was found. We'll talk about that in just a few minutes. Ms. Cox also said that Matt had a lot of blood on him, and it might have all been his own. They didn't have it tested. We don't know if it's his blood, Kay's blood, a third person's blood, but it could have all been his own, as Ms. Cox told you. But most importantly, she said she has no opinion to offer you on who did this. And really, isn't that the only question that matters? And she cannot exclude that a third or a fourth person was involved. The next witness was Detective Ritto, the lead detective. Now, he helped look for a knife, but he didn't find one. Why is that important? Well, he told you that he looked where Kay was. He looked in the backyard. He looked where Matt was found. He looked along with Lithia Pinecrest. They looked everywhere. He told you multiple deputies, multiple people using equipment, metal detectors, trying to find a knife. There wasn't one, because the real perpetrator had left with it in the 15 minutes it took for the police to get there. If Matthew Terry did this, they would have found the knife where he was laying, or somewhere close to it. Remember, we had this map. Large concentration of blood where he was found. If he did it to himself, if he cut the wounds in his neck like they want you to believe, wouldn't that have occurred where that large concentration of blood was at H, where he was found? And if that's what happened, he would have still had the knife on him or close by. They would have found it. Why do you think they didn't? Because the real perpetrator had left with it. It wasn't some ridiculously little 3-inch paring knife, little bent bird's knife. If he was going to grab a knife from that butcher block, wouldn't he have grabbed a butcher knife? Wouldn't that make more sense? The next witness, a few more things from Detective Ritto. He also pointed out, and I liked the phrase he used, which is why I want to mention it. He said that there were indications Matt and Kay normally arrived and were getting ready for bed. I agree with that completely. There were indications Matt and Kay normally arrived home. Matt's keys to the car that is in the driveway were right by the bed. If Matthew Terry did this, wouldn't he have gotten those keys, gotten that car and left? Detective Ritto told you that Kay's shoes were off. We know that because of the pictures where she was found with no shoes. Another indication getting ready for bed. Just like Matthew Terry, his shoes were off. There was no argument going on. They were going to bed. Matthew was in his underwear because they were about to go to bed. And most importantly, of course, that text at 11:56 was that everything was fine. But he also told you that he doesn't know the circumstances of what occurred because there's no evidence of what occurred. Remember that. He also told you that there were blood trails that showed someone fled. Well, of course. But he doesn't know who. He told you he doesn't know who, and that's really the question that they have the burden to answer. And they haven't. And he told you that more than 50 items were collected and 10 sent for testing. 20% sent for testing. Next, we have Detective Van Gilder. He indicated that the only knife missing from the home was that little 3-inch paring knife. Again, I'd ask you to just use your common sense. If Matthew Terry grabbed a knife from that butcher block intending to harm Kay Baker, is he grabbing the smallest knife there? Is he going to grab a paring knife that's curved instead of a big steak knife or a big butcher block type knife? Of course not. It's absurd. That's not what would have occurred. Witness 24 and 25, Detective Gibson and Detective Davis. They testified that they used metal detectors and ground wands to search right where Matthew Terry was found and didn't find the knife. Again, going back to exactly what I've said before about that. That knife would have been there if Matthew Terry did this. But that also ties into the 26th witness, Deputy Polito. Deputy Polito, you might remember, he's the one who had the bloodhound. So he told you that his hound can only track the scent that is given to him. So Canine Champ could only track that one scent. If there were other scents of a third or fourth person there, he's not going to be tracking that. Deputy Polito indicated that he stopped Canine Champ because he found a large pool of blood. I submit to you that's right around the H that Anna Cox talked about, where there's that large pool of blood. And that when he pulled out Canine Champ, Deputy Gibson and others came in order to try to find the person who was there. And in fact, it was Matthew Terry, who was just right beside that large pool of blood, because that's where Matthew Terry's neck was cut by the real assailant. Remember, if he cut his own neck right there, they would have found that knife. They didn't. Deputy Polito also told you that Matthew Terry had to be walked out of the area by deputies, which you actually got to see on the body cam. You could see, in fact, that Matt was injured. He was staggering. He had to be supported by the next witness, who is Deputy Hall. He's number 27. Deputy Hall told you that Matt was found on his back and that another deputy immediately rolled him over and handcuffed him, despite Matthew being, as described by Deputy Hall, quote, very pale, having serious wounds to his neck, needing to be assisted to his feet, assisted in walking, and that he appeared, quote, on the verge of going unconscious, and, quote, on the verge of potentially dying if medical care was not immediately given. So he did immediately get him care, got him EMS, and they transported Matthew to the hospital. Now, the deputy that had rolled Matthew over, that's Deputy Curtis. He's number 28 that we're going to talk about. Remember, though, as we talk about Deputy Curtis, what Kaylin Hall said. Matt was on the verge of dying. Deputy Curtis, though, he assumed, oh, that's got to be the killer. So he immediately rolls him over. Who cares about his injuries? Do they bother to document his injuries? Did Deputy Curtis stop for a moment to see if rolling him over might cause Matthew to die? No, he didn't care. Deputy Curtis made an assumption, immediately rolled Matthew Terry over, handcuffed him, and assumed he must have killed his girlfriend. Because the spouse, the partner, the boyfriend is always a suspect. It's an assumption. which led to the theory that the state is asking you to believe. Now, you saw it on body cam. You saw how Deputy Curtis completely disregarded Matthew's physical appearance, his lack of any ability to stand on his own, his paleness, his multiple wounds to his neck, the fact that Matt had blood coming out of his nose, blood all over him. You saw Deputy Curtis just toss him over, cuff him, and you also got to see Deputy Curtis's demeanor on the stand. Think about how he testified. He didn't even want to admit that someone could have gotten away in the hour prior to him getting to his perimeter point. Why? Because he's the one who assumed it was Matt. He's the one who immediately arrested Matt. He's the one who this whole farce was based on. The next witness, Deputy Gianni, readily admitted that someone could easily have gotten away before setting up the perimeter point an hour earlier. Deputy Curtis wouldn't even try to give any remote possibility to that, because he didn't want to accept that his assumption was dead wrong. But luckily, Deputy Gianni took photographs of Matt's injuries, so at least we have that, and we have the body cam to show you how Deputy Curtis acted in those moments. We're at 29 witnesses. Not one shred of evidence yet that Matthew Terry did this. Let's talk about number 30. That's crime scene tech Dur. What did he tell you? There were 3 blood trails. One along the fence line, one along the back edge of the property, one straight across to the decedent's residence. Now, I can't tell you whose blood that was because they didn't test all 50 plus swabs that they took. But it's not my job to tell you. It's theirs. It's their burden. But he did tell you there were 3 blood trails. And we're on the last witness now, Deputy King. Deputy King is who first found that screen off the window. You got to actually see it on his body cam. I'm not going to play the body cam, but I'll show you the picture of it. Remember, though, as I'm showing you this picture, what Detective Redo said when he testified. Now, I had no idea he worked burglaries. They brought that out. But what did he tell you? He said that first floor unlocked windows are points of entry for a burglary if the screen is removed. This is the state's 11E. First floor, unlocked window, screen removed. Now, the state tried to say in their opening, hey, wait a minute, nope, no way, can't be from a burglar because there's a stuffed animal. Really? You saw the photos of the inside of that room. There were a bunch of stuffed animals there. Someone could have taken that off, gently placed it down, not stuffed animal even there yet, crawled in and knocked out with their foot one of the stuffed animals as they're crawling in. First floor, unlocked window, screen out, gently placed against it. Not frantically pushed out onto the ground like it would have been if their theory were true. Remember, what did they tell you? They want you to believe Kay Baker, after Matthew Terry kicked in the bathroom door, kicked in the other bedroom door, chose not to kick in the door where she barricaded herself, giving her plenty of time to frantically push out the window and get out there. And then what did she do? Stop and pick up the screen to gently place it against the side of the house? That doesn't make any sense. If she were barricaded in that room, Matthew Terry would have kicked in that door too. We know that didn't happen because the deputies kicked it in to get into that room. And that screen would be further and away from that window, having her frantically pushed it out, not quietly, gently placed against the side. Doesn't make sense. And it's their burden to prove what happened. We're at the end of the witnesses. There's no evidence. None. Matthew Terry didn't do this. And I don't have to tell you what happened. All I have to do is raise doubt about their theory. But I'm going to tell you what happened, and I'm going to show you how the evidence actually shows that their version is wrong. And what is a reasonable inference of what actually occurred based on the actual evidence, the things that they ignored. Now, they wanted to read to you the reasonable doubt instruction, so do I, because the part that they never mention when they read it is this part that I've highlighted. Let's see if we can zoom in a bit. They read to you the first part because they want you to say that what I'm about to tell you is just speculation and imagination. No, it's not. It's a reasonable inference based on the evidence, and you are allowed to use anything that can be reasonably inferred in order to find out. If after carefully considering, comparing, and weighing all of the evidence, you do not have an abiding conviction of guilt, or if you have a conviction of guilt, it's one that's not stable, but one that wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find him not guilty because your doubt is reasonable. A reasonable doubt as to the guilt of Matthew Terry may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. I submit to you we have a lack of evidence here. We have conflicts in the evidence. We have doubt that arises from the evidence itself, as I'm going to go through in just a moment. But I would remind you of the very last part of that instruction, which is, if you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should find him not guilty of first-degree murder. That goes back to the very first thing we talked about. But also in regard to any crime at all, if you have a reasonable doubt, you do not have a conviction of his guilt, an abiding conviction that doesn't waver or vacillate, you have to find him not guilty. Remember those instructions as we're talking about what actually occurred. We started first with the thing we know, really the only thing we know from their theory, which is that at 11:56 p.m., there's a text that everything's all good now. So we know that. We know they got home. We know everything was fine. We also know that they're getting ready for bed. How do we know that? Kay's shoes are off. Matt's shoes are off. Matt's keys are by the bed. All evidence. We also know that there's something that occurs where that screen is gently, quietly placed against the house. I submit to you a reasonable inference is that prior to them getting home, that screen was gently, quietly placed against the house. And someone entered their home, knocking that stuffed animal out as he got in there. He's in the house, they come home. What's somebody who's entering, I'm just going to call him a burglar, it'll be easier. What's somebody who is a burglar in a home going to do if the occupants come back? He's going to get the heck out of there, right? So he hears them coming in. Where's he going to go? Is he going to go out the front door or to the garage where they may be? No. He's going to go exactly back the way he came, where he knows he can get out, because he had left the window open when he gently placed that screen against it. What's he going to do to buy himself a little time? Lock that door. That's why that door isn't kicked in, because they had no idea he was in there when they came in the house, took off their shoes. And when Matt went into the bedroom and put his keys down and took off his shorts to get ready for bed, Kay went out that front door. Remember, the front door was ajar. She heard a noise. What she heard was him getting out of that window again. Remember, he would have come in back to the room where he had come in to go out the way he came in, because that's the way he knew he could, which is why the screen is gently placed against the house. And as he's in there, locking the door to buy him a little bit more time, Kay hears the noise as he's crawling out the window, goes out in her bare feet, to see what the noise is. And as she comes around, she's attacked. And that's why her blood is all over the front there. Remember, Kay's blood is right here. There is no evidence that the other blood is hers. If you look at the key at the bottom that Anna Cox told you was correct, the yellow is Kay Baker's blood. The orange is where Kay Baker and Matthew Terry's blood got mixed. So the only place we know Kay Baker's blood is right here. And if Matt, as Anna Cox said could have occurred, got Kay's blood on him here trying to help her, which we'll get to in just a moment, and then got attacked, he could have easily gotten her blood here and here as he's stumbling to get away. No yellow here, because they didn't bother to test it. None of that blood is Kay Baker's. So as Matthew Terry was in the bedroom putting his keys on that nightstand that you actually got to see the photograph of, remember his keys were right there. He's in his underwear. He hears Kay get attacked and immediately goes out to help her. He finds her laying there, right where she's found. Bends down, gets her blood on his hands, sees the woman he loves dying, and is attacked himself. And that's how the blood ends up here. He's stumbling to try to get himself back to a point where he can see what on earth is going on, and he hits the fence there. And that's how the blood gets there too. He's able to shake it off and then chases the assailant. He's bleeding already. Remember, you can tell from the photographs, you saw blood in his nose, blood on his face, there's blood all over him. He is actively bleeding. And that's why there's some of this blood that is his. You can see the blue is his, the A and the J there, Matthew Terry's blood. But some of that pink is not his, because he goes after the assailant. He goes after the guy who tried to end Kay Baker's life, and ultimately, Matthew finds out later, did end Kay Baker's life. But Matthew doesn't know that in those moments. He's going after the person to stop him from getting away. And there's a struggle, which is why there is all that blood. Now, when we're here, you can see there's crossing over. Matt gets here. Matt's bleeding here. And the assailant is able to get further down. Now, he's still chasing him, trying to keep up with them. There's a question mark here about whether there's more blood here, because, again, they didn't bother to get that evidence. They didn't bother to take photos there. They didn't bother to document that. But as Anna Cox testified to, there's possibly even more blood along that area here before we get to over here. And I submit to you that area where Anna Cox testified, there is a large pool of blood, is where Matthew is more sufficiently and more vigorously attacked with the other stab wound to his neck. Now remember, Matthew had one stab wound here, one stab wound here, blood in his nose, blood all over his face, blood all over his clothes. So all of this is not just Matthew's blood, but it's also the burglars. And some of this back here, I submit to you, there is more blood there that they just didn't bother with. The police just didn't care. They thought they had their man. And over here, they ignored the fact that Matthew was further and more seriously attacked there and didn't even bother to test that blood. Matthew was attacked where Deputy Hall found him almost dying, pale, lethargic, as he described. And that's why Matthew was still there. Think about their theory. They want you to believe that he just laid there for 5 hours. That's absurd if he were the killer. He would have got up, got to those keys, got to the car. Why would he stab himself over here and then stay on the scene? He had at least 15 minutes where he could have just gone towards Lithia Pinecrest, crossed back over here, got into his car and got out of there. Remember, Jonathan Figgins and Ruth Figgins didn't know who Kay Baker was at the time. They thought it was some teenager. They didn't know it was her. They would have thought nothing of somebody a house over just leaving their driveway, leaving their garage. He didn't do that because he was attacked. He couldn't do it. He was laying here injured, almost dying, as Deputy Hall indicated. You heard the weakness, the quietness in Matthew's voice on the body cam when he was found. They want to say, oh, he was just laying there, he couldn't call out. You heard the weakness there. He was so injured, he wasn't even sure he could get up. He had to be helped up, assisted by the deputies, walked out, medical treatment, and ultimately surgery. Remember, it's not my job to tell you what happened. It's theirs, and they didn't do it. They have to prove their case beyond and to the exclusion of every reasonable doubt. They've given you a theory, a bunch of assumptions, and zero evidence. 31 witnesses, each one we went through. Not one points to Matthew Terry. Their burden is to protect us all. Matthew Terry is innocent. He didn't do this. They haven't proven a thing. And as hard as it is, the law demands that you go back there and vote not guilty. Thank you.
Ladies and gentlemen, does anyone need a break before the rebuttal? Seeing no hands, Mr. Diaz, you may proceed.
Thank you, I have a moment.
Absolutely.
Okay, you heard it. Ms. Perry told you what happened. It's not evidence, but she told you what happened. Matthew Terry is the brave hero who chased down the assailant who murdered his girlfriend in an attempt to apprehend him. That's what she told you. She didn't have to tell you the story. She said she would do it anyways, and she did. Okay. So, Kay Baker and Matthew Terry are in fact the last two people together. He's the last person with her, right? They're home alone, right? They got home. They started to get undressed. Everything was going normal, right? That's what they said. And some man decided to break into their home. Homes do get broken into. He doesn't break a window. He pulls the screen off. The window to a child's bedroom their mother has left unlocked is left unlocked so it can be opened. He kindly takes the time to raise the blinds, because the blinds are raised, right? They're not pulled down. They're not crawled through. He takes the time to reach inside and raise the blinds, and then he crawls in through the window. And now he's discovered that there's people home. So he decides he's going to get out of there, and he's going to take the time to lock the door first before he climbs back out the window. That's the story, right? He doesn't put the blinds back down to conceal his retreat. He doesn't close the window. He doesn't put the screen back. He just crawls out the window and he walks away. And Kay Baker, and only Kay Baker, hears this noise. And what a woman does in the middle of the night with a man in the house, she says, I'm going to go wander outside alone to try and figure out what the noise is that I hear inside my house. That's what happens, right? She has to wander outside. That's clear. She's got to get outside the house. She doesn't die inside the house. She's got to wander outside alone with a man in the house. She doesn't say, honey, I think I heard a noise. Could you go check? And not to be chauvinistic, women are certainly capable of checking for themselves. She doesn't go room to check, right? She just immediately walks outside barefooted. Doesn't take her phone, doesn't use it as a flashlight, doesn't bring it so she can call for help if there's a problem. She fully exits her home, as depicted here in State 64B, which she exits over here on the left side, the side away from 6209. And though she's heard a noise inside her house, she walks all the way past the front of her home, through her driveway. She walks across the yard between her home and 6209. She crosses past 6209 for no appreciable reason, and there she is set upon by the burglar, who is still hanging out waiting to murder her. Right? The guy who was in such an effort to get out of there has decided to hang out at 6209, so a woman who's coming walking through the driveway in the open public space, he's just waiting, and now he's not a burglar, he's a cold-blooded killer. That's what has to happen. Right? There's no suggestion in the story that Miss Perry told you that Kay Baker chased him out of the home. She was running after him to try and stop him. She fully described the notion that the guy got out the window, fully got away, and Kay Baker decided to wander outside alone, doesn't bring her boyfriend, doesn't call the cops, doesn't bring a flashlight, doesn't bring any weapon to defend herself. She wanders out into the night to look for what is a suspicious noise. And she gets murdered. She gets murdered in a most intentional and a most premeditated fashion by the Phantom Killer. And somehow, Matthew Terry, who's just chilling inside the home in his underwear, hears a noise and decides to wander all the way out from the bedroom, which is in the back left corner of the home, all the way to the front of the home, all the way outside, all the way past the front of 6207, through the yard heading into 6209, past the yard of 6209, and somehow he knows that his girlfriend is laying dead on the ground of 6209. And by the way, the cold-blooded killer is still just hanging out. He's just waiting. He has to be. Right? Because there has to be enough time that Matthew Terry can walk up to the scene, see his girlfriend laying dead on the ground, and make the conscious decision to get on the ground and render her aid, because he wouldn't have to know that the cold-blooded killer is standing right there, knife in hand, ready to murder him. Right? So the cold-blooded killer has now lain in wait a second time for a reason that he doesn't have to think that another person is going to come along, so he can kill a second person in what started in a home burglary. And now he attacks Matthew Terry, right? Because Matthew Terry's got to end up with Kay Baker's blood on his hands. And what the defense has told you is, that's Kay Baker's blood on his hands. Right? That's what they said. Matthew Terry gets the blood on his hands because he's rendering aid to his girlfriend, because he's the good boyfriend. And now he's being knife attacked. And even though Jonathan Figgins told you that he heard the sound of a female voice, right? Which has to be Kay Baker, because Matthew Terry isn't a female. And I guess you could conclude that the person who was wincing in pain as if they were being injured was the Phantom Killer, but that seems a stretch. Jonathan Figgins hears no noise of a second fight. There's no yelling, there's no screaming, there's no calling for help, there's no anguished noise coming from the mouth of Matthew Terry as a knife is now being plunged into his neck. Not a fatal wound. Nowhere near the level of the extent of injury that's done to Kay Baker. And according to the defense, it's just a one. He stabs him one time in the neck because they still got to leave room for the second neck wound that's going to happen later. Right? Now Matthew Terry has been stabbed in the neck and he is stumbling through the yard. Right? Conveniently depositing his blood and Kay Baker's blood all over the place. And for no appreciable reason, he runs up along the fence line He's not putting his hand on the fence as if he's supporting himself because he's so weakened and so beat up. He goes all the way down the fence line and doesn't touch the fence with his hand until he gets to the north facing. The facing Lithia Pinecrest. That's where his handprint is. It's on the north facing. It's not where Z and Y and X and W and V, it's none of those. Right? So now the cold-blooded killer is watching Matthew Terry stumble helplessly along a fence line and doing nothing. He's not going to finish this guy off, right? There's no second attack. There's no wound to the back of Matthew Terry. There's nothing. He stabs him once and then watches the guy wander off. And then, if Matthew Terry goes north along the fence line, the killer doesn't run south. He doesn't run east through the front of 6209 or west past the front of 6211. He doesn't run anywhere opposite the man that he's just tried to kill. He decides to run through the backyard of 6209 and 6207, and somehow, even though 30 seconds ago Matthew Terry was stumbling weakly and helplessly through the backyard, now he finds the strength of conviction to chase him through the yard. That's what you have to believe. He is suddenly possessed of the moral fortitude to chase this man down. He doesn't say, I should probably go help Kay Baker, who's not dead yet. Because when Jonathan Figgins finds her, she's not dead yet. The killer has left the area where Kay Baker is. He's running northwest through the yards, and Matthew Terry doesn't say, go save Kay. Go help Kay. Go scream and yell and call for help. Go bang on the door of a neighbor's house. Nothing. He's now just going to chase this man who's armed, who's already supposedly nearly killed him once with a knife, through the darkness and through the bushes, down the dark side of Lithia Pinecrest. Which has to ignore the complete fact that the blood pattern here shows somebody was lingering, hanging out. It's not the phantom killer. No one stabbed him with a knife. No one's beaten him up. The person who's bleeding is him. It's the defendant. He's got to be lingering. Why is he lingering? That's what the blood pattern shows. The person's lingering in the corner. And now the killer goes through the bushes, and Matthew Terry, girlfriend still on the ground, still dying, still bleeding to death. Every heartbeat that she has is killing her. Says, I'm going to keep chasing this guy through the bushes. I'm going to go further into the darkness. I'm going to go further away from people. I'm going to go further away from help. I'm going to go further away from any person who can do anything to make the situation any better. I'm going to keep chasing the guy with the knife. And he runs all the way down the road, a football field, chasing this guy. Just a bit ago, he was weakly stumbling along a fence line, but now he's got the strength to chase him down a football field. And then we get to here. State 64A. The killer has run away from Matthew Terry. Matthew Terry has chased him this whole distance. And now the killer decides to turn and do a second round of attack on Matthew Terry. And miraculously inflicts an almost symmetrical wound on the other side of the defendant's neck. This guy isn't just a killer, he's deadly accurate. Right? Matthew Terry has no other wound. There's no wounds to his hands. The doctors don't have to repair wounds to his hands. Right? Defensive wounds. You know who's got defensive wounds? Kay Baker. You know why? Because Kay Baker was attacked with a knife. That's where the defensive wounds are. You saw them. Matthew Terry's got no defensive wounds on his hands. He's got no stab to his abdomen, no stab to his face, no stabs to his arm. This phantom killer stabs Matthew Terry once over by Kay Baker, and then miraculously hits the exact opposite side in an almost mirror identical situation over here. And now Mr. Terry is bleeding all over the place. Even though Anna Cox tells you that there's lots of bleeding that's occurring and it's spattering everywhere, blood is spilling from Matthew Terry everywhere, right? And the killer decides to walk away. He doesn't finish off the eyewitness. He doesn't finish off the person who the killer could reasonably conclude would say, yeah, I saw the killer, this is what he looked like, he was 6 feet tall, he was whatever. Right? He doesn't finish that guy off. He stabs him a second time and then he leaves him. That's what you have to believe. He leaves him. And Matthew Terry is what? Now he is conveniently weak again. Now he is conveniently too weak to walk because he's being attacked, according to the defense, at the back of 6221. Here's State's Exhibit 3A. There's 6221. Right? Matthew Terry has got home after home after home, and even if you say, well, he's stuck in the backyards and there's nowhere that he could go because the backyards are fenced, he's got to go exactly 3 houses and he's at the end of the cul-de-sac. Right? He's back on the street. Remember how the defense has gone to such great pains to tell you all how accessible this neighborhood is, how easy it is to take the walking trails, how easy it is to just walk down the cul-de-sac, how easy it is for a person to get in and out. But Matthew Terry, who's now been attacked twice, hasn't the foggiest clue what's happening with his girlfriend, who's bleeding to death in a neighbor's yard. He lays down on the ground. Right? He has no strength left now to do anything, to scream, to yell, to bang on a fence with a stick, to walk. Just walk. Walk a few houses down and get access to the cul-de-sac and find any person. Any person. None of that happens. None of that happens. There is nothing reasonable about that. You can play that game all day long, and you will exactly do what is possible, what is speculative, what is imaginary, and what is forced. That is exactly what you would do. The defense tells you that there is no indication that the doors in those homes were broken that night between Matthew Terry and Kay Baker. And I challenge you to go look at all the photos, because the state of Florida put photos in of every room of that home. A home that is filled with 2 children. Kay Baker was the mother of 2 children. And go look and see how clean that home is for a mom of 2. Go look and see how lovingly, how carefully all the dishes are arranged in the dishwasher. Look at the photo of the closet, how all the clothes are hung. Look at the photos of the kids' rooms and how relatively neat they are. I mean, you can guess the relative age of these kids. They've got stuffed animals. They've got a Hot Wheels track. Right? And look at the things on the ground. Look in the master bedroom and look at the strike plate and the piece of the lock that are sitting on the ground directly in the area Matthew Terry would have had to have walked that night when he got home and went to put his keys on the nightstand. If that door has been cracked for days, if some apathetic landlord didn't bother to clean up the mess, it would have had to have been sitting there for days. Nobody picked it up. Nobody did anything about it. Go look at the hallway outside the children's bathroom. Go look at the kid's bedroom that doesn't have the open window and look right at the entrance, and you'll see the strike plate on the ground from the bathroom. And right next to it, you'll see a toothbrush still in its packaging, the plastic wrapper. That's been sitting there for a long time, and some kid never picked it up, never moved it. It just conveniently got left there all that time. There is nothing reasonable about any of that. Nothing. Matthew Terry killed Kay Baker. You, as a jury, are tasked with deciding what was in his mind at the moment that happened. But there is only one logical conclusion, and I promise you, it doesn't have the first thing to do with the phantom burglar who turned into the cold-blooded killer for no appreciable reason. One person was angry at Kay Baker that night. One person was arguing with Kay Baker that night. One person was alone with Kay Baker in that house that night. And one person has Kay Baker's blood on his hands, both literally and figuratively. That man. He killed Kay Baker. He killed her with premeditation. He plunged a knife into her over and over again, and when she was in a moment of weakness, on the ground, he opened her neck. Not by accident, but on purpose, with one intent. That is who Matthew Terry is. That is who Matthew Terry was on that evening. Do not believe in the phantom burglar. Find the defendant guilty as charged. It is the only just verdict. Thank you.
Ladies and gentlemen, we are going to take a short break before I read you the instructions. You've been sitting for well over 2 hours. I am going to instruct you not to do any research related to the case, not to discuss the case amongst yourselves or with... Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. It is time for the final instructions. I am going to turn on my microphone again, and I am going to read to you instructions. Again, these instructions will go back with you in the jury room. So, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I am about to give you. Matthew Terry, the defendant in this case, has been accused of the crime of murder in the first degree. You should consider the possibility that although the evidence may not convince you that he committed the main crime of which he stands accused in count 1, there may be evidence that he committed other acts that would constitute a lesser included crime as to that count. Therefore, if you decide that the main accusation in count 1 has not been proved beyond a reasonable doubt, you will next need to decide if he is guilty of any lesser included crime as to that count. The lesser crimes included in the definition of first-degree murder are second-degree murder and manslaughter. Matthew Terry is accused of first-degree premeditated murder in count 1. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find K.E. Baker was killed by Matthew Terry, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following circumstances. Number 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Matthew Terry may be found guilty of first-degree murder or any lesser included crime. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Number 1, Kay Baker is dead. Number 2, the death was caused by the criminal act of Matthew Terry. Number 3, there was a premeditated killing of Kay Baker. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix an exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Matthew Terry did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Matthew Terry was in fact so provoked and did not cool off before he committed the act that caused the death of Kay Baker. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. If you find that Matthew Terry committed the lesser offense of first-degree murder, and you also find a reasonable doubt that during commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of first-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Matthew Terry committed in count 1 the lesser offense of first-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of first-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Kay Baker is dead. Number 2, the death was caused by the criminal act of Matthew Terry. Number 3, there was an unlawful killing of Kay Baker by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Unact is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that Matthew Terry committed the lesser offense of second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is defined as 1. Any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2. Any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Matthew Terry committed in count 1 the lesser offense of second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second-degree murder. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Kay Baker is dead. Number 2, Matthew Terry intentionally committed an act or acts that caused the death of Kay Baker. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Matthew Terry committed the lesser offense of manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of manslaughter with a weapon. A weapon is defined as 1. Any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2. Any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Matthew Terry committed in count 1 the lesser offense of manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of manslaughter. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that he lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he knowingly consumed a substance that he knew or should have known could cause intoxication. Matthew Terry has entered a plea of not guilty. This means you must presume or believe he is innocent. This presumption of innocence stays with him as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome his presumption of innocence, the state has the burden of proving that the crime with which he is charged was committed and that he is that person who committed that crime. Matthew Terry is not required to present evidence or prove anything. Whenever the phrase reasonable doubt is used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of his guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction of his guilt, or if you have a conviction of his guilt, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find him not guilty because your doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of Matthew Terry may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. If you have a reasonable doubt, you should find him not guilty. If you have no reasonable doubt, you should find him guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Has any pressure or threat been used against a witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The evidence which has been admitted to show other crimes, wrongs, or acts allegedly committed by the defendant will be considered by you only as that evidence relates to proving an intent, identity, or absence of mistake or accident. However, the defendant cannot be convicted for a crime, wrong, or act that is not included in the indictment. The Constitution requires the state to prove its accusation against Matthew Terry. It is not necessary for him to disprove anything, nor is he required to prove his innocence. It is up to the state to prove his guilt by evidence. Matthew Terry exercised a fundamental right by choosing not to be a witness. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should be concerned that Matthew Terry did or did not testify at trial. A statement claimed to have been made by Matthew Terry outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence whether his alleged statement was knowingly, voluntarily, and freely made. In making your determination, you should consider the total circumstances, including but not limited to 1. Whether when he made the statement he had been threatened in order to get him to make it, and 2. Whether anyone had promised him anything in order to get him to make it. If you conclude that his out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law. Everyone is depending upon you to make a wise and legal decision. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or because you are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in any way. Whatever verdict you render must be unanimous, which means that each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your responsibility. I cannot participate in that decision in any way. Please disregard anything I may have said or done that makes you think that I prefer one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser offense as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which was proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must also be in writing, and for your convenience, the form of verdict has been prepared for you. Thank you. I have it here. It is one page. I know you can't read it from there. I'm going to hold it up. What I do is I take it out of the stack. As I indicated, the instruction to go back with you, the verdict will be on top of the stack. It reads as follows: State of Florida v. Matthew Robertson Terry, and then it has the title verdict form. Under that it reads, we the jury find as follows as to count 1. Then in parentheses there are instructions that say check only A, B, C, or D, plus any other specific findings. Then it says, then A reads, the defendant is guilty of first-degree murder as charged, and under that there is two statements with lines next to them. The first says, during the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use a weapon. Or the second line reads, during the commission of the crime, he did not carry, display, use, threatened to use, or attempted to use a weapon. Under that, choice B reads, the defendant is guilty of second-degree murder, a lesser included offense. And then there's the same two choices. I'll read them both. First, during the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use a weapon. Or, under that, it reads, during the commission of the crime, he did not carry, display, use, threatened to use, or attempted to use a weapon. Under that, choice C reads, the defendant is guilty of manslaughter, a lesser included offense, and under that, two findings. The first, during the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use a weapon. Or the second reads, during the commission of the crime, he did not carry, display, use, threatened to use, or attempted to use a weapon. Then choice D reads, the defendant is not guilty. Under that, it says, so say we all, dated this blank day of November 2022. And then there are two lines, one for the foreperson of the jury to sign their name, and one for the foreperson of the jury to print their name. In just a few moments, you will be taken to the jury room by the bailiff. The first thing that you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to return the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction that I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. That is all of the instructions, and as I said, I am taking the stack, and that will be coming back to you, as well as the exhibits. It may take us a little bit of time to get those back to you. I'm putting the verdict form on the top of the stack of instructions. There's one last thing before I send 12 of you back there. There's 13 of you in that box. We always select alternate jurors. In fact, in this case, we used 2 of our alternate jurors. I'm going to ask Mr. Christian Gonzalez to remain behind. Mr. Gonzalez, you are our alternate juror. I will have some additional instructions for you, but I'm going to send the rest of the jury back to begin deliberating at this time. You can take your notepads with you into the jury room now. All rise for the jury. You need to keep them?
We don't have to keep them.
Okay. Yes. Is she?
I emailed it to Jeanette. Can you just print the one page? Or not?
Last time
I didn't know.
printed out in a different
Okay,
format.
then I'll just send it to you.
Send it just in case as a backup. If we can print it here like these, that's fine. Well, I'm not placing it up here yet because we're putting a slightly altered.
We'll have to go through all the evidence anyway.
Right. So I'm going to put it up here for now, and then when we get the new one page, it might be printing now. I'll invite you all down to take a look at it, approve it, and then we'll substitute it.
Okay.
Before we do a final version of the jury instructions, I just want to talk to counsel.